Very well. Where is the notice?
Well, I have the notice.
দেখো তো ইয়ে কবেকার নোটিশ?
Today I saw. Yesterday I also sent email. Today morning for in park, our senior.
ফাইলটা রিকুইজিশন নিয়ে আমার সঙ্গে কথা বলুন।
No further mentioning. Here it is. Item number 1 under arbitration. Item number 1. Last one. Item number 2. Item number 2.
I'm responding. 2024 matter, but yet not copy, sir.
Who is the কে আছে দেখো তো অ্যাডভোকেট?
Mr. Ajay Singha.
Ajay Singha. You inform Mr. Singha that this matter will be taken up in the second court. What is why is this CO in arbitration? Because scope of revisional application in arbitration matter is very limited. Huh? You are for the railways. You appeared on the last year. Ajay Kumar Singhani and Saurabh Kaur appeared. So why didn't you ask for this copy of the survey, copy of the application? See,
Also,
see, there are bunch of orders. First,
also.
see, first it was taken up on 14/6/2024. Submits for delisting of the matter since it relates to appointment of arbitrator. In view of the submission, the matter is delisted. Very well. Then 29th July 2024. Pre-arbitration conciliation. What has happened? Is there any, did any discussion take place?
Upon instructions from the conducting council, Lordship.
Yes.
He is on his way, but his tires got punctured. His car's tire. So, Lordship, we will serve in the course of the day kindly.
What course of the day?
The
Why-
service has-
When was the matter filed?
Lordship, just give-
I am giving you, please madam, look into the order. You have volunteered to appear, so you have to take the responsibility.
I mean, like the updating project, the conducting council has requested me. Clearly.
Ask him to be present. I am
Pass. Get.
train late, tire puncture, flight delayed, new excuses. But the court starts at 10:30.
Item number 3.
Yes.
I am for the respondent number 2, 3, 6 and 7.
Yes.
I am for the respondent number 2, 3, 6 and 7.
Yes. What is this matter about? What is this matter about? Maybe, Mr. Mojumdar.
Lordship,
Yes.
Lordship, actually, it matter relates to an arbitration award that was passed. It is, my lord, is a non-statutory arbitration. The
Ah.
parties agreed. My lord, we have filed one application because there appears to be some mathematical error in the award.
Hmm.
For correction of that, my lord, only this much. Last date,
But mathematics.
I apologize before Lordship. On the last occasion, the Honorable Court had directed us to file a reply to the counter filed by the respondents. My junior
No, correct. If it is arithmetical correction,
Lordship.
then the arbitrator has the authority.
Lordship, within 1 month.
Yes, why didn't you go?
My lord, it was detected much after when the respondents filed an application, when the arbitration award was put into execution, the learned executing court found out the defect. So 1 month period was elapsed, my lord.
Now tell me, if it is a non-statutory arbitration,
Lordship.
will it be under writ petition or will it be under Article 227?
My lord, as your lordship very well knows, and no need for me to reiterate it. Constitutional remedies have no block; they are always available.
No, see, under the Telegraph Act,
Lordship,
if there is an award,
lordship.
challenge to the award is in the writ jurisdiction.
My lord, arbitrators, my lord, I would humbly submit, my lord, that Section 37, in view of the latest pronouncement of the Supreme Court, has given that age of modification and correction of award.
Yes. Now 37,
Lordship.
will it be before the single bench or a division bench?
My lord, that I have to check out, my lord. I frankly confess, my lord, because arbitrations in North Bengal and AP petitions are very rare. And my lord, like by presiding officers like your lordship, they take up. Otherwise, my lord, it is very new to us. Let me check out, my lord.
Because see, there is a dispute, but so far as I am aware, I can give
My
you a
lord.
judgment of Justice S.B. Sinha,
My
where
lord.
probably Justice Sinha had opined that it should be before the division bench.
Lordship.
Now there are subsequent judgments. Now, what is the impact on that judgment? Because
Lordship.
no point in keeping the because if it is a 34 application
Lordship.
for setting aside of the award, then definitely it has to be before the single bench.
Lordship.
But if you say it is directly on the 37, then it may be before the single bench or maybe
Before the division bench.
Which one?
My lord, 50% of whatever the researches that I made, it indicates towards the division bench. But there are some instances where the honorable single judge has dealt with 37 applications. My lord, let me examine this one, my lord.
Because I have doubts. See, if you look into the judgment of reported in 2007 1 SCC 467, you will get the uh, uh, discussion over there.
My
Under
lord, kindly repeat the page number.
2007 1 SCC 467.
Lordship.
37(2) before the principal civil court of original jurisdiction.
Lordship. That is the district judge.
Ah.
My lord, may I just come in here? Sorry, my lord, only on the question. Your lordship is asked just to assist the honorable court and learned DSG. My lords, we did a matter where, my lords, we referred to a Supreme Court judgment of 2017 in Simplex Infrastructure, where the
Yeah.
court has said that 37 appeals should go before a division bench.
Yes.
Insofar as single bench is concerned, my lords, that happens only when your lordship is sitting in the principal bench at Calcutta, since your lordship have original jurisdiction there. Otherwise, all matters, my lords, at least in Siliguri, Darjeeling, etc., where there is no original jurisdiction, it goes before the commercial court. After
Yes.
commercial court, your lordships here 37 appeal sitting in division bench. Is, my lords, my understanding. And my lords, there's a Supreme Court judgment, my lords, on this, I believe, which is Complex Infrastructure of 2017. Justice Khanvilkar has gone into this.
Yes, I gave you 2007. That is Justice
Yes, my
SB,
lords. They follow that.
37(2). Justice Sinha has said it used to go. It should go before the principal civil court. Now
Please, my lords.
with the Commercial Courts Act coming into force, arbitration matters are commercial disputes under 2(1)(c). So then it will where it will go. That is a dispute.
Yes, my lords. Your lordship is right.
So that you have to check into, because I don't think the issue can be left undecided before I entertain, because it will be a infructuous exercise.
My lord, I fully understand, my lord. This is the registry who channelizes the application. If it goes before the DB, I have no problem.
I have read Simplex, but I don't have the recording over here. Can you tell me Simplex citation?
My lords, I'll just find that out, my lords.
My lord, Simplex is 2017. My lord, gives me 1 minute, I will find it out. Simplex Industries.
Simplex Infrastructure, sir, versus Union of India.
Union of
Fine,
India, 2017. I may be having it. Let
My
me
lords,
check.
this is Simplex Infrastructure.
I may be having it.
My lords, actually, the issue is with Simplex, there are multiple judgments. So it's, I think, a 2017 one.
Osmin, यो arbitration अग्रवाल का उसमें ये रखो कि जजमेंट में Simplex ऑफिसर.
Our DP is for
My lord, may I give the citation, my lord? Simplex Infrastructure, my lord. (2019) 2 SCC 455.
No, probably that is the Simplex. That is in respect of arbitrator chosen by the party.
Yes, my lord.
That
Yes,
is,
that's, I think, Justice Chandrachud's judgment, which is a different judgment. So there is another simplex of 70. I'm also trying to look for the
Yeah, this is
citation.
Dr.
D.Y.
this is
Chandrachud,
by
yeah.
D.Y. Chandrachud.
Yeah, the question there was different.
because subsequently there is a judgment of Justice Nariman, which
Lordship.
has taken care of that 2019 judgment of Justice Chandrachud, because there was an issue of venue and seat, which has been subsequently clarified. Very well. When can you come back?
My lord, Monday, anytime.
Very well, because see, I won't be having much time left. As it is, I am taking only up to 12. I may choose to sit a day up to.
My lord, it is your lordship's convenience is the paramount, my lord. Tomorrow, day after tomorrow, Monday, whichever suits your lordship's
You
time.
can come on Friday, it will be better. Friday.
Right, my lord.
ফ্রাইডে দেখবে কিছু রিটার্নেবল আছে, এই আরবিট্রেশন গুলোকে যেটা হয়ে যাচ্ছে বাদ বাকি গুলোকে ওপরে দিয়ে দেবে, তারপরে ওই যেগুলো ওই দিনকে আছে সেগুলো অন্য হেডিং এ করবে, কারণ যে মোশন গুলো টাচ করা যাবে না সেগুলোকে আবার অন্যদিন নিতে হবে।
My lord, if I just, if I am permitted, my lord.
Oh.
My this CO is headed under section 11 of the application arbitration conciliation act. It is not purely under 37, my lord.
If it is 11, then what is the situation? দেখি কাগজটা দাও তো, দেখি কি চাইছে।
My lord, only the correction. Either because since the arbitrator initially was the opinion that I am functions officio, but thereafter the Supreme Court or judgment came in which said that no, for correction and rectification, arbitrator does retain jurisdiction. So we have come under 11. Either this arbitrator does it or a fresh arbitrator be appointed.
No, 11, how can it be?
Well, we are not challenging the award.
11 is for appointment of arbitrator.
Actually, my lord, it should come under
34.
33, my lords.
33.
33 is before the arbitrator.
Yes, my lord.
So
34 will be district court, my lord.
34, that is the whole difficulty. It will be before the commercial court.
My lord, let me examine this.
Very well. Because now see, after the recent pronouncement of the larger bench, that partial modification of the award is permissible. So, if even if it is arithmetical correction, it can come under partial modification
Yes, my lord.
of the award.
Lordship.
So the court can do so.
But my lord, the
My
word
understanding is that.
yes, my lord. But the word used by the lordship was this court. Now, when their lordships use the word this court, that restricts the forums, my lord.
That is where I have a
My lord, let me examine.
Friday.
Lordship.
Number 4, under motion.
Milords, in item number 4, Milords, before my learned senior starts for the petitioner, Milords, I am an auction purchaser. The bank has taken possession of the property on 9th. I have gotten possession on 10th. I have not been served a copy, Milords. So, Milords, I have to be heard in this matter.
Very well. Sorry.
No, just, Malad, hear me for a moment. Give me a short pass for 10 minutes because certain eligible copies were there, Milad. And even I obtained the certified copy. I am making an affirmation implementing affidavit with those documents illegal. Let me come after it is in the affirmation, Malad.
Very well.
10 minutes.
Milords, may direct them to serve a copy to me, Milords. Auction purchaser, I have possession today. They have not made me party is what I understand, Milords.
You are not a party in the deportee section 14 application.
No. Milords, today I have possession of the property. They
Very
are
good. You want to
accurately...
intervene, but seek an intervention, take out an intervening application.
No.
Then if the Malad permits me, then definitely I will serve.
No, Milords,
The issue is,
Yes.
where is the bank? Yes, what is the situation?
We have taken the possession to the order and we have handed over the possession to the.
Yes, my lord. So I am in possession
And the
today.
Scenario is that whether this law at least lie before your honor, because section 34 has given the just the power to take the possession on behalf or by the help of the DA and to hand over the possession to the bank. Bank has subsequently given. They are not the borrower, they are not the guarantor, they have purchased the deed. Who are deed, they are coming before a DA, they have lost the case there, they have preferred an appeal. So if there is an appeal pending before the DRT, so why he is making an application right here right now?
No, it was submitted yesterday. That's the reason I gave
Yes, ma'am.
leave. That the DR80
Yes, ma'am.
is not operational.
My lord,
Because-
that's an incorrect statement. I have all the orders of DRAT. My lord, my colleague will hand over. DRAT is
My
functioning.
application, my lord, why my application? Let me place my case, my lord. Then you hear me? Then
My
if
lord, that's unfortunate and incorrect submission is made. All
what
orders are here, my
unfortunate
lord.
incorrect submission, I am within the record. What I said yesterday within the record. I'll show you yesterday's only.
Mr.
on the DRAT.
Chaudhary, no point in fighting
No, but
intersect.
incorrect statement,
Because
never,
you-
my lord. This is not my habit. Never. Such a, if I make any incorrect statement, then definitely, my lord, the statement which is making my lord friend cannot be, my lord, accepted, my lord.
I don't take
Yes.
it up today and
Yes, that's good.
I am ready with my.
Very good. Yes,
That's
that's
the
the
main party man.
because in section 14 you have not made a party to the
There is no scope of making you a party.
That's
Because
that.
entire statute states that the borrower is the party. If you have to make a claim.
I'll understand. Hear me. What I say?
I am also hearing you. I am telling you. My lord is hearing you.
Very
I am
well.
not
You
here
get
to
the
give you
supplementary affidavit. I am keeping it after 10-15 minutes.
My
My lords, will ask them to serve me a copy on email. My lords, let me go through the petition.
No, I definitely I will. If I find that you are a necessary and proper party, I will definitely.
Grateful, my lords. Grateful. I am obliged.
Item number 5 under civil motion. Item number 5.
Mr. Bormon, you are appearing for the respondent.
Proceed. Notice has not also not been served. We have received information from the Planet Transport that they have obtained a stay. We are appealing by filing on.
Very good. Yes. Yesterday I heard you.
Millard is hearing this for the first time.
Oh yes. Very good.
Millard, should I serve a copy and come back tomorrow?
What is the matter about?
Millard, it's a section 10 order which is into. Millard, according to us, it was incorrectly stated.
Incorrectly stated.
Yes, the section 10 was allowed. We are against that. Millard, I'll serve a copy on Mr. Verma since he is appearing. Millard, I'll serve a copy and I'll come back tomorrow.
Very good. Tomorrow or day after tomorrow, tell me.
As your lordship pleases. Monday.
Everybody is asking for one day. That is the whole difficulty.
Help it to.
Friday, very
Right,
good.
grateful. We are filing.
একটা order করো Mr. Hirok Bormon, learned advocate, instructed by.
My client responded.
No. You are you have a junior in this matter, or you will be filing the vocalat. ठीक है. Very well. Hirok Bormon, learned advocate, appears on behalf of the respondent. Appears and submit that he has the instruction to appear on behalf of the respondent. Let a copy of this application be served on Mr. Bormon. Full stop. Let this matter appear on Friday করে দাও.
Item number 6.
Madam for the question.
This is that matter.
Amendment. Amendment before the arbitrator refused.
Statement of claim rejected by the.
Revisional, you have to,
Application.
Uh,
27.
how do satisfy?
Yes, ma'am. I'm coming. Milord is on the point of maintenance.
Maintain it, you may have a relief, but whether it will be in a 227.
Yes, ma'am. I'm coming. But the first judgment that I'm referring to is of the Delhi High Court. This is a very recent judgment, Milord, of 2024. This was also considered in a subsequent Supreme Court judgment. Milord, the relevant para is para 10. This is Milord Kelvin Air Conditioning versus Triumph Reality. Relevant para is para 10 at page 3. Milord will kindly read from serial 24, the last part, a perusal of the above mentioned decisions.
No, what was the order over there?
The order here, Milord, they had filed a section 227.
Just a minute.
Yes.
এই মলয় চট করে থেকে এই বইটা নিয়ে এসো তো জাজমেন্ট দিচ্ছি প্রিন্ট আউট হোক বই হোক যেটা হোক এটা আনো টোয়েন্টি 15 SCC 706
Yes, Milord. That is Deep Industries. It has been considered in this judgment. This Delhi High Court judgment refers to that judgment and also many other Supreme Court judgments.
Very well,
At page 3, Milord. Deep Industries, I'm aware of. Deep Industries versus.
Yes.
Now, this
Next.
is the first one. Next, my lord, is a division bench of the Karnataka High Court. In a completely identical case, where an amendment was rejected by the arbitrator, challenged before the Karnataka High Court under Article 226. And my lord, the observations are at paras 23 onwards.
That is one of the reasons I said 226.
My lord, Delhi High Court talks
Hey,
about
hey.
226 as well as 227.
See, 227 superintendent power
Yes, my lord.
and 226 as an inherent power.
Yes.
See, prima facie, you have to have a remedy. The Supreme Court has said, not now, in 1993-95, that if the substantive law does not provide for a remedy, the court is to devise a mechanism to grant, because no one can be left remediless. Now today, if you have to challenge an order of amendment, a refusal and order of amendment, is it a appealable order or is it a revisable order? If it is a suit,
It is
Because-
a suit, then it's a revisable order.
revisable order. No, there are cases, if you look into which rejection and allowing. Suppose you are aggrieved by the order allowing the amendment, then what? The
My lord, in both cases, 115 that proviso would not apply to my knowledge, because in both cases it would not amount to finality of the suit. So
no,
115
absolutely.
Yes.
That is there, because amendment, if you look into the division bench judgment of Justice Rumapal, you will find that amendment does not create or confer any right, nor does it take away any right.
Yes.
Because even if the amendment is allowed, you have to prove your case.
Yes.
Only thing in case of amendment, what are the parameters to be found? Whether it is a time-barred claim which is being sought to be introduced by way of amendment, or an amendment which changes the nature and character of the suit, or it takes away any admission or tries to wipe away any admission already made in the plaint.
Yes.
Now, if you look into the provisions of the Arbitration Act, now you will find, like a suit, you will find a Arbitration Act though. An Arbitration Act then থাকবে।
Section 18 perhaps.
No. 2. Section 2. Court means in case of arbitration, other than international commercial arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the question forming the subject matter of arbitration, if the same had been the subject matter of a suit but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. So, as if the suit. Now, if you come to order 6 rule 17, ACPC দাও তো। Yes.
My lord, if I may just supplement to your lordship's observation on Order 6 Rule 70, it kindly takes up section 23(3) of the arbitration. My lord, the scope of amendment in any arbitration proceeding is, my lord, much more vast than what has been provided in Order 6 Rule 70.
There is
Because
no,
Order 6 Rule 17 provides a specific rider that after the trial commences, you have to satisfy whether you have been able to, why you have not been able to bring up the amendment.
no, order 6,
There is that rider.
normally, no, the proviso says, normally when the trial has commenced,
Yes.
no amendment should be allowed.
Should be allowed.
Very well.
Unless you are able to satisfy, why haven't you been able to come in? That is the proviso. But my lord, section 23(3) of the arbitration. It specifies unless otherwise agreed by the parties.
Yes.
Unless otherwise agreed by the parties, either party may amend or supplement his claim or defense during the course of the arbitral proceedings. Does not talk about commencement of trial. Unless the arbitral tribunal considers it inappropriate to allow the amendment or supplement having regard to the delay in making. So the arbitrator is only empowered to decide on the delay. Here, my lord, the amendment was made only after 1 month of the cause of action, which arose. The arbitrator's hands are tied. He has to only decide.
I will hear you.
He only has to decide on the delay. If there is substantial delay, then he may refuse to allow.
Oh. It does not, the arbitrator's satisfaction does not restrict him in respect of the delay.
My lord, I'll show your lordship a judgment on. Lord, has seen this division bench. My lord, kindly takes up para 32. I'm sorry, my lord, para 23. Para 23. Page 5 of the judgment, para 23, last paragraph.
Yes.
It says, from the reading of subsection 3, which is 23(3), it is apparent that the onus is cast on the arbitrator to analyze and assess as to whether it would be suitable or proper to allow the amendment. In other words, the arbitrator is called upon to conduct a judicious exercise of appreciating not only the nature of the amendment sought, but in conjunction with the delay in seeking the same. And such appreciation should not cause a mere displeasure, but indignation, that is strong displeasure, enough to convince a prudent mind that it would cause injustice to one party or it would not appeal to a prudent person as being righteous or judicious to grant the application. The delay referred to in subsection 3 of 23 of the Act cannot be a mere ordinary delay, but delay of such nature that it would cause a sense of revulsion in a prudent person or judicious mind.
Absolutely,
Please, my lord.
absolutely incorrect, I will say. Maybe a division bench. I am not bound by it. It has a persuasive value. Now let us see, in a case
Yes.
where you are seeking to include a claim, when does your cause of action start?
No, I did not seek to include a claim.
When does your cause of action start in a arbitration proceedings?
My lord, when the notice is served upon.
Notice is served.
Yes.
So your call, see, there are two form of limitation in case of arbitration. One, your substantive claim is barred by limitation, and the other is application is barred by limitation. I give you the arbitration is an original claim.
Yes.
Now, if you come after say 3 years from accrual of your cause of action, suppose you have done a work and you have not been paid. Now, there is no final bill or of that sort. Then, when you assert payment and it has not been given to you, so 3 years will start running from that day. So if you come after 3 years, your substantive claim
Is barred.
is barred by limitation.
Yes.
So you cannot maintain a arbitration proceedings to realize that claim.
Yes.
But you can still then maintain an application for section 11
No, my lord.
because
Yes.
where there you can file it because you have given a notice under 21. 3 years will be reckoned for the application from the notice. So suppose you had asked for payment of the claim in the month of January. He did not pay. So reasonable period from that and 3 years will be the limitation for the substantive claim.
Yes.
Now today you will if you give a notice under section 21, say after another period of 2 or 3 months, in the month of say August, then your 3 years period for filing the application will under Article 137 will continue for 3 years. So you can file an application under section 11. Then the court will look into whether the substantive claim is barred by limitation or not. If it is a time barred claim, court will refuse even at the stage of appointment of arbitrator, may refuse to appoint an arbitrator. So two limitation periods operate in case of arbitration matters.
Yes.
Now today, if you want to include in the, suppose you had got an arbitrator appointed. At that stage, the point may have been raised by the respondent that your claim is barred by limitations. But often, if it is not a stale claim, the Supreme Court has said, if it is not a stale claim, then it should be placed before the arbitrator because it's a mixed question of law and fact. So the arbitrator will decide it. Now, this is the settled provision of law. Now, in such a case, if it is found by the arbitrator that no, there is reason prima facie to believe that the substantive claim may have been barred by limitation, he may ask for certain evidence to that effect and can decide it at that stage before deciding into the other grounds on merit. If you look into such a scheme, then suppose you make an application for amendment to get out of the provisions of, now I'm giving a
Such is not the
hypothetical,
case.
it may be a hypothetical situation. Suppose you make you try to make an amendment to put in certain more facts to establish, no, there was an admission, there was acknowledgement, so the substantive claim is not barred by limitation. In such a situation, will this observation hold good? It's not a generalized thing.
No, my lord. This observation is with regard to 23(3) only. It does not.
Yes,
the
I'm saying
definition of the substantive.
23,
That has been, my lord,
23.
decided.
23(3), you have to look into from this angle.
Yes.
One, when you are asking, I'm borrowing your language. Suppose the arbitration proceedings is continuing.
Yes.
Now, at a stage, you find that you require to amend the statement of claim or the statement of defense.
Yes.
Now you bring an application. The arbitrator in that case will look into that the stage when the amendment is sought to be made.
Yes.
Whether the delay is such that, borrowing the language of the division bench of Karnataka High Court, is such that the strong displeasure. Now here also I will say the choice of word should be different, because pleasure or displeasure of the arbitrator cannot stand in the way of a legal claim or a legal matter.
Legal amendment. Yes.
So whatever may be, he has the right to look into the aspect of when the application is made.
Yes.
Now, this does not limit. If you look into the wording of the section, unless otherwise agreed by the parties, either party may amend or supplement his claim or defense during the course of the arbitral proceedings, unless the arbitral tribunal considers it inappropriate to allow. This inappropriate
Read the
is,
entire sentence up.
yes,
Only with regard to having the delay.
yes, no, inappropriate to allow the amendment or supplement having regard to the delay in making it.
So the propriety of the amendment only has to be gauged
or supplement.
No,
Or supplement.
or supplement, and this entire exercise of gauging the propriety of the amendment has to be only with regard to the delay in making.
This
To my
no,
limited
that is where I join issue with it.
Yes.
With you, because he was trying to read that the arbitrator is only entitled to look into the delay. No, arbitrary delay means delay can be of two types. I explained it to you.
Yes.
Delay is of two types. One, when you are coming during the proceedings to amend after a considerable period of time, when the arbitral proceedings has commenced to a great extent. So the period when you come, or the appropriate juncture when you come, is a concern of the arbitrator.
Yes.
Because the whole scheme of arbitration is for expeditious disposal of a matter. That is one. But at the same time, suppose you try to bring in a stale claim. It may happen that you can ask for an amendment.
Then he had every right to reject it.
So you
Such is not the case.
no. Then I again fall back to your own admission says that in there can be two different situations.
Yes.
In two different situations, the same parameter cannot be used. One, the delay. Suppose you try to amend it, you want to include a claim which is still alive.
Yes.
Then the period of delay in bringing the or in making the application as under 23(3), according to you, is the only concern of the arbitrator. But if it is a stale claim, then inappropriate.
Then, my lord, it is hit by the delay itself. If it is a stale claim, then too it is hit by the delay.
Delay, no. So I explained it to you. To amendment. See, if you look into the judgments of the Supreme Court, you will find there is at least one case where a amendment was allowed. I can give you the judgment.
Lord, I have brought those judgments.
Amendment was allowed, but prima facie it appeared that it was beyond the period of limitation. So in respect of that claim, the Supreme Court identified and clarified that it should be reckoned from the date of the amendment. Otherwise, normal judgments are, when you make the amendment, it relates back to the date of the original filing. In that judgment, the Supreme Court had made a clear departure and said, no, because you have to prove it, we are not shutting it out.
The amendment cannot be
we are not shutting it out, but it will be reckoned from the date of the amendment, and no, it will not relate back or date back to the original file. So in such a situation, the arbitrator may also take recourse of the view of the Supreme Court.
Yes,
That I
he could
can
have.
I can allow a claim. I can allow a claim because
No, that is my-
it is no more res integra that it is no more res integra that amendment applications are to be looked into liberally.
Yes.
Even there is at least one judgment to my knowledge, which clearly says that if it is found that the suit is not maintainable in view of the attack made by the defendant, then also the Supreme Court has said an opportunity of amendment should be granted if the suit can be allowed to survive. There is at least one judgment to my notice. I can give you the judgment. So in such a situation, the question is not today on the merit, because I will go into the merits of your matter only if I am satisfied that I can exercise jurisdiction under 227.
No.
That is presently that is the issue. So I am not going into the merits at this stage. You satisfy me, then obviously I will look into the merits.
Let's seize a very recent judgment of our Honorable Justice Shampada Topal before the principal bench.
Hmm.
My lord, identical case, my lord. In this case, the amendment was allowed, and my lord, 227 was filed against such allowance. What is the observation of our Honorable Court, my lord, in the month of May 2025? The judgment is short enough, my lord may have a look at it. The second page onwards. Page 3, my lord, is the relevant part. Para 7 onwards. Takes into consideration the Supreme Court judgments as well as the Delhi High Court judgment, and my lord comes to a finding.
No, this is on the merit, but
Yes.
I am on the principal issue.
My lord, in the 227 application,
Maybe if somebody has not taken an objection.
our Honorable Court has returned a finding
What finding?
on the issue
What
of
finding?
amendment. Of amendment.
No, amendment is something a different issue. Now, whether the refusal to allow the amendment is amenable under 227 is the issue.
But I have shown your lordship Kelvin air conditioning of the Delhi.
Kelvin, what does it say? It was if you see into Kelvin,
Yes.
Kelvin was on a different issue altogether. The Karnataka High Court judgment is on Order 6 Rule 70.
Yes.
Now, today, if you look into the Karnataka High Court, does it decide the issue 227 or yeah?
226 and 227, it does.
The answer to your question has been given in paragraph 23 of the division bench judgment. 22 and 23.
Yes, my lord, I was referring to that. 22 and 23.
Where does it decide the 227 issue?
This 227 was allowed.
Maybe, but where does it decide that the court has the jurisdiction under 227?
Lord, if the
When-
court
when-
exercises jurisdiction, that itself
When the
means-
Supreme Court has said
Yes.
that 227 is not, will not lie.
No. Supreme Court has not said that. My lord, I beg to differ on that score.
Deep construction,
Supreme Court,
paragraph 11 probably.
my lord, it has said that it can be exercised in cases of perversity and exceptional rarity. That is what the Supreme
See,
Court has said. It has not
perversity-
limited the power of the
Perversity or exceptional, that has to be
that has to be
under-
shown.
under 227 or 226.
My lord, both. In these matters,
Because
arbitration matters, 226 and 227 has been seen in the same way. To my limited understanding, 226 as well as 227 has been seen in the same way, and the Supreme Court has not taken a rigid view that you have to go in at 226.
What was the, now, very well.
Yes.
No point in wasting, I will look into this issue.
Yeah.
What is, let me get his,
Yeah,
what is the amendment you
Yes.
sought for?
So, my lord, this arbitration was one of specific performance.
Uh,
Everything was under within limitation. I also obtained an injunction order from the arbitrator. Now, my lord, the impugned amendment, the amendment sought for, my lord, is at page 106. Page 106 of my application. The proposed amendment is at page 108. In italics, that is the amendment.
100?
8. 108. So, Lord, what had happened that during the arbitration proceeding, when the issues were about to be framed, this loan amount was sanctioned,
Which loan amount?
this 75 lakhs,
Yes.
in favor of the claimant
Hmm.
for purchase of the property, which is the subject matter of the arbitration.
Hmm.
So, within a period of 1 month thereafter, I sought to bring forth this amendment. That during this period, this loan has been sanctioned by the bank for purchase of that particular property. So that is a necessary amendment.
Was made prior to that, application was made prior to that. After that, it got sanctioned with January.
And immediately
So,
after that,
continuous cause of action, continuous cause of action.
immediately after that,
See,
within a month,
you realized that you won't be able to, in a suit for specific performance,
that is
readiness and willingness.
Yes.
that was the
Readiness and willingness.
This point.
my lord, my readiness and willingness will be proved as per the recent Supreme Court judgment, which
I
says
am getting those.
that if substantial amount of in a specific performance is already paid,
At the
that
time of
itself indicates towards the readiness and willingness of
At the
the
time of
party.
getting in.
So on the merits,
merits,
merits, I'm okay, my lord. But this will only
Have
fortify.
you annexed the statement of claim?
Yes.
Yes. Statement of claims. Statement of claim starts from page 32. Page 34 onwards is are the above. Page 34 onwards.
Yes.
That is the statement of claim. Statement of defense is there.
Which
Hello?
page?
Statement of defense is from
No, statement of claim, which page? Sorry.
page 32 onwards.
Yes.
Page 32 onwards. Milord sees the
Objection at page 90.
the injunction order, Milord, at page 98.
No. Statement of defense?
Milord, 93 onwards. Page 93 onwards.
Lordship has taken up item 7, I'm sorry.
No, sir, item 6 is done.
I'm sorry.
Yes.
So, my lord, that is not under dispute. I have also been
In the
blessed.
statement of claim, have you said that you had applied for the loan?
No, my lord, at that point it was not applied for. During the pendency of the arbitration, when after obtaining the injunction order, my client also approached the bank because a loan was already sanctioned before, but that was the time period had lapsed.
What is your statement about that?
My lord,
In the statement of claim?
my lord, in the statement of claim, if I don't bring that, and if during the pendency, all pre-trial amendments are
They
to
were
be
not
allowed, my lord,
ready
that
with
is the
the money.
principle.
They were
All
not
pre-trial
ready with the
amendments
money.
are to be allowed. That is the principle.
Very well, I got it.
If
Yes.
during the pendency, my lord, this loan has been sanctioned. I'm only wanting to bring forth this amendment. The merits may be decided at the time of trial. Whether this will entitle me to the claim or not, that will be decided at the trial.
I'll look into it.
My lord, on the point of maintainability, my lord, since my lord has gone through section 20 subsection 3, I'll take your lordship to section 19 of the arbitration act. Lord, determination of rules and procedures. The arbitration tribunal shall not be bound by the CPC or the evidence act, subject to this
The
part.
TPC or Evidence Act is not, but
Yes.
principles analogous thereto are to be followed.
So, but tribunal is not bound. My lord, parties are free to agree on proceedings to be followed by the arbitral tribunal in conducting its proceedings. Failing any agreement referred to subsection 2, the arbitral tribunal may, subject to this part, conduct proceedings in the manner it considers appropriate. So, my lord, what does the amendment comes? So, if the tribunal is not bound by the CPC or the, so how there can be a amendment of the?
No. 23, the Arbitration Act is a complete code in itself.
My lord, on that
If
score,
it is so, then 23 is very clear.
yes,
You can amend or supplement, add or supplement.
add or supplement. But
No.
the tribunal is not bound. It is up to the tribunal. Now, section 23.
Sir, the difficulty is that you are trying to make a case which has no limbs to stand upon.
Lord, on
Don't
that
go,
score, I would like to
don't make,
for
don't
one
make.
judgment, Lord, of the Honorable Supreme Court, Lord, say infrastructure versus staff drilling.
Yes,
Milord.
what does it say?
Lord, paragraph 11 and 12.
No, on what point?
Lord, that tribunal is not bound to follow the CPC. Lord.
Here, who is disputing it?
Lord, kindly take some.
Who is disputing it?
Lord, so maintainability of the section 2 of the 227 application, where is the maintainability? Lord? How is this section 227 is maintainable?
Now tell me one thing, plain and simple question. I had told you, for the sake of repetition, I am again repeating.
Yes, sir.
Can one person be left remediless?
No, my lord.
Then he has to have a forum.
Yes.
He is aggrieved by his rejection of the amendment. Now he can go for recalling of the order. But if the recalling,
But
say, if the recall,
227, how could it come? Lord? How could he?
I am
Lord,
unable
kindly
to.
takes up the judgment, Lord. Paragraph 11 and 12. Kind of. Paragraph 11 and 12.
Yes, there is no dispute regarding this.
Lord, another judgment I would like to place Supreme Court, wherein Order 6, Rule 17, guidelines are framed. Latest judgment of Justice Aniruddha Bose and J.V. Pardiwala.
Milord, if he is on the point of amendment, Milord,
Milord,
I would also want to seek on, Milord, seek reliance on judgments. There are numerous judgments on the point of amendment, Milord.
Milord, here the amendment application must be dealt with utmost care, Milord.
Really, I'll look into it.
And lastly, Milord,
Which paragraph?
Milord, paragraph 6. Milord, and lastly, Milord, Rebel Jetu Builders versus Nagaswamy, Milord, wherein the orders Rule 6, Rule 17 amendment application, the Supreme Court held that the application for amendment of claim deserved to be dismissed with cost of rupees 1 lakh, Milord. Milord, Rebel Jetu Builders. For wasting the precious court's time, it was dismissed with the cost of rupees 1 lakh.
Milord, there's two judgments I'm referring to, Milord, of the Honorable Supreme Court on the point of amendment.
And Milord, readiness and willingness judgments, Milord, I can refer to your Lordship, Milord. This is 2022 and 2024 in the case of Rabindranath Sashikala and UN Krishnamurthy, where at the time of performing the agreement of sale, they should be ready with the money. If they are not ready with the money, they shouldn't have applied for the loan of 75 lakhs, which they have obtained from
What
state
about
bank.
the 30 lakhs that you're planning to see?
Yes, that, Lord, on that score,
See, that is not a, I can even arrange for money by taking a loan.
Milord, that is after the contract, Milord, after the agreement for sale. How could it be possible? Without any money, they have gone into the agreement of sale. Milord, after that, they will arrange money. After they will buy the property. Milord,
That is a question of evidence.
Milord, may I hand
That
over?
is a question of evidence.
Milord, may I hand over? Milord, may I like to state a few facts in this case. Milord, agreement of sale was made on 7th September 2020. I am stating the facts of this. It was valid for 3 months. In the meantime, the petitioners have paid some of this 30 lakhs also. Milord. Within 3 months,
What was the amount to be paid?
1 crore 15 lakhs. Out of that, they have paid some amount, Milord. To 20%, 30% they have paid. Milord. After that agreement was valid a period of 3 months. For a period of 3 months, they didn't bother to pay the remaining money. They didn't bother to get the property registered in their name. So that agreement for sale goes. Thereafter, as a good gesture, I sent a lawyer's notice that the agreement for sale is no longer into existence. Take back your money within a period of 15 days. Otherwise,
These are all merits. I'm not. These are all merits.
Thereafter,
Why should I go into this?
facts,
My first
facts in this case.
My first question is one, whether it will be a 227 or it should be a 220.
I have satisfied, Lord. With those
226.
with those
The
judgments,
other
Lord,
party is on the merits. Now, see, amendments have to be looked into liberally.
Yes.
Now, whether he
But
is
we-
trying to bring on a fact which would change the nature and character of the suit
it will
is
change, Lord. After obtaining loan, they will give me the money. Then again, another 5 years I have to wait for that money.
Nature and character change one of specific performance to something else. If I bring for this amendment, this is a,
then I will look into it.
yes.
Milord, thereafter, the original agreement for sale in subclause 12, there was an agreement for arbitration. There was a clause for arbitration. That clause was invoked by you. Thereafter, arbitrator was appointed. Milord, statement was claimed filed, statement of defense filed. Thereafter, for a period of 6 months, 7 months, they have filed amendment application.
The matter has been substantially heard.
Not just to Jalpaiguri, sir.
Huh? No. Substantially heard. Let this matter appear on মঙ্গলবার দাও, ঠিক আছে, for to enable the learned advocate to add or supplement to their submissions already made. So, Passover matter conducts.
Passover matter, item number 4.
যেটা ওই ইয়ে ছিল।
Passover matter, item number 4.
Yes.
এটা ওই বইটার সঙ্গে দেবে আমার, বা এটা একটা কাজ করা হয়, জেরক্স না প্রিন্ট আউট নিয়ে। হ্যাঁ ঠিক আছে, তাহলে বইটা লাগবে না। ইয়েস,
Certificate copy will not, such an update is shall I value the department? I have made a photocopy also.
you give it to
And this is my also my supplementary people are annexing the documents which are illegible. And also 1, 2, 3 documents are more which are added not been available at the table.
very well. Have you served them a copy?
This is the big only.
Then Mr. Chaudhary, I have to give them a time.
Copies are there, Milord. That is their documents only now.
Maybe.
Kindly appreciate one thing. When a fraud committed upon the court, Milord.
Who has committed fraud?
Bank.
How could the bank commit?
Yes, I am answering. Good, I am not answering.
See, if I have correctly understood, you purchased a property, you are X, you are A. You purchased a property from X.
Yes.
Now, X had availed a financial assistance from the bank by creating charge or equitable mortgage in respect of the property you purchased.
Which is not permissible under the circumstance. Before purchasing of the property.
No.
Please, if you please have a seat plus, let me complete.
Don't get
Then
excited.
definitely, why you are so? It is the communication we are exchanging between the honorable court and me.
Please take your seat, no difficulty. I will hear you out. Now, so the bank's case is that it is a security under the SURFACE Act.
Yes.
Now, there was a default on the part of the vendor from whom you purchased.
Yes.
Now, the bank has proceeded against him under the SURFACE Act.
Yes.
Now, this person, this X, he did not divulge you all these facts.
Yes.
So, your case is that you are a bona fide purchaser for without notice about the mortgage.
Yes.
Now, fraud, if any, has
Doesn't come in.
no fraud, if any,
Yes,
fraud, if any, is committed by whom?
No,
Committed by X.
I committed fraud upon the court.
Where?
Court. Why? Why? But kindly see the application before by way section 14 before the court, which my lord I have handed over, my lord. Kindly have a look.
Tell me.
My lord,
Your case will be, I can anticipate, your case will be, you had gone before the DRAT
yes,
prior to the section 14 application.
yes,
The bank was aware
Yes.
about your stand.
yes.
Bank did not divulge about these facts in the section.
Which plan?
Mr.
Before
Mr.
My
Chaudhary,
lord.
at least this much experience I have, no difficulty.
No, my lord. Definitely this is my lord. I have my lord the even the enough my lord, what to say the confidence on lordship. My lord, kindly appreciate one. The 14 application will flow from a 13.4 application. The moment 13.4 application is the
No.
matter to be adjudicated.
13 no. See, first 13.2 notice.
Yes, that I
Then
that's
13.3A
yes,
reply.
yes,
Then 13.4.
yes,
Then symbolic position.
yes,
Then section 14
yes.
for taking actual physical possession and delivering it to the auction purchase. In between the auction purchase has taken place.
Malad, when the
When did
notice
it-
was when the notice was published for such sale proceed, Milord.
No,
I-
sir. Because see, what is your case? Your case is that I was not aware about all these things.
Yes.
The moment I came to know the bank has tried to take possession, I had gone before the appropriate forum.
Yes.
I was not given interim protection, but my matter is pending.
Yes.
So if my matter is pending,
Yes.
how can the bank
Invoke
without
14.
without affording me an opportunity?
This is a one part. But Milord, the 13.4, because my objection is that these twofold objections before the Milord the DRT. One objection is that this is the charge or the property which has been created by an equitable mortgage do not fall and hid by section 31. Because this is an agricultural land, it cannot be do not fall within the meaning of the Surface Act of 2002 by your 31. This was my first fold of argument. Second, I say the issues, the tribunal, the DRT, which has not been formulated. By way of challenging this twofold, I filed an application before the DRT tribunal, Milord, by way of an essay application. If essay application was taken over, shall I?
No.
The essay application was taken up, Milord, and the court found that I don't have any merit. Essay was rejected. Challenging that, Milord, I have preferred an appeal before the DRAT. Milord. DRAT has formulated certain observations. Based on the observations, DRAT sent back to the DRT. On the basis of these observations, are afresh hearing to be given, and then matter to be disposed of by the DRT. DRT reiterated the same the order which initially he has dismissed the application by an essay. So, Milord, that is in the month of December 2024. My rejected. Then in January, Milord, I filed an application before the DRAT. There was a delay of 5 days. By this time, caveat was filed. So, Milord, when the 16th January, my application was admitted by the DRAT, Milord. In the meantime, the notices and all were served. They are in receipt of the notice. Milord, they in the meantime, during the pendency of that, in December, when the application which is remanded back to the DRT, which has rejected my application, then on 2012-2024, the bank filed an application before the court for taking position for an aid of taking position by of section 14. But if your lordship sees in section 14 application before the court, then it is the duty incumbent upon the bank to disclose, yes, this is the position matter is in season or whatever, or this is the fact.
Now
In
what is
contrary,
the,
for a second.
now what is the situation? Let us.
Yes, Malad, just a second, Malad. I'll quickly, I'm concluding, Malad. Malad, in contrary, by an affidavit before the court, bank said no litigation or proceeding or suit is pending. That is the observation by the learned ACGM, Malad. So, Malad, then thereafter, matter finally disposed of in April 2025 with the by appointment of a commissioner, so that are taking assistance from the police. And day before yesterday, in the afternoon, they have taken over my, which is an agricultural land. Still, by agricultural purpose, it has been used. Day before yesterday's photographs showing that these are the agricultural produces. I have a photograph, and even the commissioner is appointed, your lordship. The commissioner report will speak that still date I am cultivating this land. This is the photographs, Though, your lordship, I do not bank upon these photographs, but by an affidavit, I said that is the agricultural land. Now, what tribunal hold? Tribunal said a document placed before the bank by my vendor while obtaining the financial assistance, the land is agricultural land converted from a bust. That was the document they have placed before the bank. Bank on the strength of that had sanctioned. Whatever. Tribunal is also acted upon, despite the observation of the DRAT, that this land squarely falls in the agricultural land and agricultural purposes, hid by 31. So please consider afresh what the DRT had done. DRT, without ascertaining, examining that yes, the land is agricultural or not, based on the document which they have availed the financial assistance.
The difficulty is that the order of the DRT
Yes, sir.
is not the subject matter of challenge before me.
No.
So what DRT has committed error, despite there being a.
No, I'm not there, brother. I'm not, because your lordship, even by your 227 application are very limited score, Melon. Very limited score. My first before your lordship, why 227, Melon? I have come before your lordship. I am squarely covered by a judgment of the Honorable Supreme Court, that is in 2007. I will rely on. My first fold of argument is that the litigant must come before the court with a clean hand, disclosing all facts for the purpose of deciding the matter in issue, which the bank squarely, miserably failed purposefully. That did not disclose the position, committed fraud upon the court. I will rely on judgment of 2007.
It's not required at this stage. Now,
Today
the scenario is that they have taken possession of your land,
Milord,
and they have what have you done?
We have handed over to the auction purchaser.
Auction purchaser. So let me add the auction purchaser. I will restrain the auction purchaser
yes.
from further dealing with the land.
Milord, may I tell little? Lordship, I'm grateful, Milord. Lordship, I'm grateful, Milord.
May I be allowed to submit?
Huh?
May I be allowed to submit?
No, I will hear out. I will hear out.
Because the submission is the very instance wrong, because the order was passed by the learned DRT on 2nd December 2024. We are
See,
filed the application
today, by virtue of the subsequent event, the auction purchaser has also got a right to ventilate his grievances. Now, today I have to give him a chance. At the same time, if the auction purchaser transfers the property to a third party, there will be multiplicity of judicial proceedings. So I will restrict the auction purchaser from not further dealing with the property, so that I can hear it out. I require a elaborate list of dates. Have you brought any list of dates? I do not know.
Yesterday, they have solved the matter.
Because in CO application, as Malad has pleased to direct me to serve, but in CO application,
Take down.
Milords, may I just submit Milords 2 points? Milords, just 2 or 3 dates, Milords. The DRT order was passed on 2nd December 2024.
Yes,
They filed an appeal outside the period of limitation, Milords, on 21st January 2025 before the DRT.
16 January.
Milords, I have the order sheet, Milords. My
I have
colleagues
a
can
copy.
hand over.
Very well.
Mr. Chaudhary, please let me complete. Milords, they filed it beyond limitation, whatever the date may be. The appeal, my lords, lied in defects for few weeks. They did not take steps. The order sheet records that. We've, my lords, filed our objection to the condonation application before the DRAT. They have, my lords, not even pressed for a hearing in the appeal or the condonation application. In the meantime, my lords, on 7th April, 7th April is, my lords, the date when, my lords, the learned CJM passes an order under section 14. Today, my lords, we are in June. My lords, I ask myself the question, what is it that the petitioner was doing for last 2 months? And the petitioner has approached your lordship in the last moment, creating a situation as if he has no remedy. So, my lords, my first submission on maintainability is that this is not even maintainable. And my lords, second thing, my lords, I must clarify. My learned senior again and again.
I, in a lighter vein, answered your question what the petitioner was doing. Actually, the petitioner went to Mr. Chaudhary, not to you. If he had gone to you, you had taken prompt steps.
Milords, perhaps, Milords, but Milords, what I also want to say, Milords, in address, Mr. Chaudhary, Milords, continuously made a submission that this is an agricultural land. There is a farmer who's farming. Now, Milords, kindly see who's the petitioner, kindly see the name. It's a private limited company who's into construction activities. And Milords, I have their memorandum of association, their latest financials. I don't understand, Milords, how is petitioner farming on that piece of land? And Milords, the last point, Milords, Mr. Chaudhary said that he purchased the land from the predecessor, which is also factually incorrect. What he did, Milords, is he purchased the land on the strength of a power of attorney, which was executed by the predecessor. That sale transaction.
See, all these things I will hear you, but first you have to be made a party.
No, my lords, I am grateful that your lordship.
But at the same time, if you transfer the land, then the whole application will become infructuous, multiplicity of judicial proceedings.
No, my lords, my only
either you have to give an undertaking that you will not transfer, or I will injunct you.
No, Milords, my only submission is this. Milords, today, when the maintainability of the petition itself is in question, and Milords, your lordship will have to consider that.
The moment you raise the maintainability issue, this rings a bell in the mind of the court that probably you have some other intention.
No, Milords, I have absolutely no intention. I will give my statement that we will not transfer the land. That's not a problem. Milords, but what is happening, your lordship may kindly consider. Milords, your lordship will essentially allow a litigant to come to the court last minute, even though he had 2 months' time since the passing of the impugned order.
I am not allowing him. He has filed a litigation. He has filed a. I had heard it. You had appeared. You say I am an auction purchaser. So a bona fide right has accrued in your favor. I am adding you as a party. And let me dictate the order.
Very well. Milords, may I just say this and leave it there, Milords, to your lordship's wisdom and judgment.
And I will be keeping it on either Monday or Tuesday. You come.
Your lordship may not restrain me. Your lordship may clarify that any transaction with respect to the land will be subject to outcome.
No. Sorry.
Your lordship, it will be subject to outcome of the proceedings, Milords.
No. Sorry, sir. My experience on that side and as a judge is different. Sorry.
No, Milords, just one thing in
I
that
will
case.
injunct you. Sorry.
No, Milords, in that case, Milords, what Milords may also clarify that your lordship's order will not come in the way of the DRAT proceedings. Let that continue. Milords, they will then use this order there.
No, I'm not doing anything. I have to hear it. I require a list of dates because everybody is giving his own piece of date. I need a copious list of date, which will allow me to record the sequence. Take down.
Malad, may I just for a second, Malad? Your lordship, well, I'm so basically your lordship, I'm grateful, Malad. You are injuncting them. One thing kindly consider. Malad, this for one day, the entire 5 bighas or 6 bighas of land cannot be Milord. The position cannot be taken by physical position.
No, Milords. Now, Milords.
Again, just a second. Bear with me. So, Milord, kindly maintain. So, no further construction should be allowed, Milord.
No, Milord, this is,
My lord,
They are constructing the boundary wall.
No, my lord, the
They
status
are-
quo cannot be given, my lord.
My lord,
আমার
I
তো
want-
বলতে দিন, আমি তো বলতেই পারছি না, বলুন।
Definitely will
Who
say.
are you? You have sold out, you have washed your hands.
But they are making allegation that we have made an application before a DA.
Not
Restrain,
the end, CG.
No, no.
restrain yourself to that part. Now today, you have given him the possession to defend that right. He has to come forth. You can support him, you can assist him, but you cannot vouch his cause. Whether he will he will
Construction
continue
of-
with cultivation or construction, it is his prerogative. You have washed your hand, you have sold it out, you have got the money, you have sold it out. What is your right? Your right was that of a mortgager,
Yes.
mortgagee. Now, in case of mortgage, mortgage could have been redeemed. So you said there is a default, you proceeded as a security. Now, for the difficulty with the banks, you will proceed against the agriculturist for default of few lakhs of rupees, but you cannot proceed against the big bulls who will swindle out your crores of rupees and will be staying some in private islands in somewhere else outside the country. This is the whole difficulty. The person whom you find that he is present, you will catch hold of him. But you will be unable to catch hold of those persons who will swindle out the public money and go out of the country.
Milords, may I, Milords, say this? Milords, Milords, I don't have a copy of the petition till today. Your Lordship
I
is adding me, Milords, I understand. But Milords, giving them an order today, Milords, will be a fiat accompli, Milords. The DRAT proceedings will be rendered infructuous. And number two, Milords, the order passed by...
DRAT proceedings is on a different footing altogether.
No, Milords, you kindly consider the effect of any order that your Lordship today passes. What happens, Milords? They have lost before the DRT. They have filed an appeal before the DRT. They are not pressing that appeal. Today, Milords, they have come in challenge against an order under Section 14, where, Milords, the learned CJM has only done a ministerial job. He can't get into the dispute at all, Milords. And Milords, I can show those judgments to your Lordship. In against that order, Milords, they are coming in 227. This is unheard of, Milords. There are multiple Supreme Court judgments where the Supreme Court is clear that when there is an alternate efficacious remedy, and given that this is only a ministerial job that the learned CJM is doing, there cannot be, Milords, either a 226 or 227. Let me, Milords, place one judgment of the Supreme Court.
Let me give you one judgment also.
Yes, Milords.
That has been clarified, you are not there at that time.
See, you look into AI 2015 Calcutta 306.
Milords, I'll look into that. Milords, will just see one paragraph and Milords, I will rest my case there. Just one paragraph. My colleague will hand over the judgment in Milords Balkrishna of Supreme Court, Balkrishna Rama Tarle. Milords, my colleague is there in the court, Milords. He'll hand over.
That is also I am relying, my lord.
Yes. So, Milords, let me read out one paragraph, Milords.
Give me a copy, give me a copy.
Milords will kindly see para 18 straight away.
Just a minute.
Milords, this is second last page, para 18.
Mr. Chaudhuri,
Please.
you said you have some difficulty tomorrow.
My lord.
Milords,
Because
I have no difficulty. Let a copy be served. I can, Milords, respond.
tomorrow, because see, it's already 12:20, I have to sit in the division bench.
My lord, with a limited period, my lord, kindly injunct them. My lord, any day. Only I have a difficulty. My lordship say I'll come back Friday. I'll come back Friday.
Friday.
I'll come back. I'll just show personal difficulty. I'll come back Friday.
Very well. Then on Friday, I'm keeping this matter on Friday.
Then, my
Milords
lord,
may not pass any order in that case, Milords. Milords, I
No.
request your lordship not pass any order, Milords, in this fashion. Milords,
it's
let a
not
copy
the
be
fashion,
served.
Mr.
Let me-
Mittuka. Please,
Let a
you
copy
want
be
this?
served.
You are referring to paragraph 18.
Yes, Milords.
My lord,
May I read that, my lord?
in the judgment matter reaches to this honorable Supreme Court. That is the
Mr.
order
Chaudhary,
approach.
Mr. Chaudhary, please, you've had your chance. I didn't disrupt you. Please let me complete.
It is not a question of disturbing. Question of that, I am just trying to assist the honorable
No,
court.
I'm doing
This
that.
is my
I'm capable
only
to do
small endeavor which I can make. The
No,
endeavor is that, my lord.
Mr. Chaudhary, you
the
started
order-
on the wrong note. You said you're coming here because DRT was not functioning. That was your premise.
I have never said the DRT was not fun. DRT chairperson is on leave. I said that. I cannot say it's not functioning. Please remember my words. I said on my each and every day matter was taken up. My DRT chairperson was not there. I have a notification. My lord, kindly see this order went in before the honorable Supreme
Milords,
Court.
para 18, Milords.
Just a minute, leader. Let me read.
May I read, Milords?
Let me read.
Yes, Milords.
What is the position now about the DRAT?
DRT, my lord, I have filed on 11th January 2025, my lord.
No. Position means
The notices were served.
no. Is the chairperson
When the matter was taken up the last occasion, the chairperson was not there, my lord. Matter was adjourned. Previously, when my lord in April,
what is the situation now?
now
My
the
instructions
functioning.
It's functioning, Milords. My instructions
Summer
are.
vacation is going on.
Yes.
Summer vacation is going on. Not going on. Please. It's over. I have not that idea.
Because my instructions are DRT is functioning. I have all order sheets and kindly see how they have proceeded from January to June.
My lord, DRAT is a separate my lord of proceedings. My lord, if you see the Balakrishna judgment, my lord, just for a second, my lord. Please kindly see, my lord, the head note. My lord,
I am not interested in, I have seen paragraph 18.
and
Paragraph 18, Supreme Court has said that you go under section 70.
but High Court had
I entertained it.
But High Court entertained. Supreme Court affirmed. This is an application when before the Honorable Supreme Court. Kindly see hence held High Court rightly set aside the order of ADM. So, my lord, it is the order challenging the High Court. Supreme Court observed the High Court intervention was correct. And a
No,
limited
because-
score. My lord, I am where I am.
But
Definitely the DRAT or definitely not DRAT. DRT will take up the application if any section 17 application is filed, my lord. That is the appropriate recourses, my lord. I have no hesitation. My lord, I will approach, but kindly appreciate one aspect, my lord. The moment I will approach the section 17 application before the DRT tribunal, tribunal is say I have dismissed your application. You invoke the jurisdiction of DRAT. How I will entertain
No, no,
the
no, no, no.
17 application?
Section 14 creates a new.
My lord,
Milord.
section 14 definitely new cause of action arises of a section of Milord D
No.
13(4), Milord.
no,
Milord, kindly,
no, no,
Milord,
no, no.
High
You have
Court,
every right to go.
Milord, High Court jurisdiction, Milord, kindly
No,
see
I-
2007 judgment, Milord. Kindly.
No.
For a second, Milord.
Let me,
Milord,
either then you have to come tomorrow or I.
Lord, no more, judge. Lord, thanks.
The matter, this civil revisional application has been filed by a third party. No, by a third party court, has been filed by the petitioner, who claims to have purchased a plot of land. Who is that respondent? Have you made?
Bank, here, Milord.
No. You
Before the
purchased it,
DRAT.
You have purchased
Oh.
from whom?
OP2.
from opposite party number 2 by a registered deed of sale, purchased
Milord, deed I have annexed, Milord.
কি বললাম এটাতে?
Purchase a plot of land from opposite party number
Oh.
by the registered deed of sale.
Dated
Number 250 dated 18/3/2020.
No, your deed number. Yes, that I am preferring. You will. You felt
I'm saying that
you are
the deed that is-
so jealous, over jealous, my lord.
I'm just
Milord,
suggesting.
1682
being deed number 1682 of
2017.
2017. Date registration date.
4th April 2017.
Sale dated 17. From OP2 বলেছি তো? Post of. OP
Milord,
Oh,
Sobita
opposite-
Srivastav, Milord. Sobita Srivastav.
OP2 opposite party to prior to it appears that OP2 prior to selling the property to the petitioner had obtained a financial assistance from OP1 bank, and had created the said plot of land as a security.
What is the date of the financial assistance? Milord, just name.
19/11/2010.
The financial assistance was given on 19th
November 2010.
2010 postal. It is also the case of the petitioner that the petitioner was not aware about the financial assistance or any alleged default committed by the
OP number 2.
OP2 postal. Petitioner being a bona fide purchaser for value was also put into possession of the said plot of land. Suddenly, the petitioner came to learn from the steps taken by the bank for
Notice of auction, sir. Notice of
That
auction, sir.
bar comes under the states of.
about the financial assistance and the default committed by OP2. Full stop. The petitioner immediately had approached the jurisdictional debts recovery tribunal under section 17 of the Securitization Surface Act
Act.
already. ঠিক আছে? The section 17 application was incidentally dismissed by the DRT. Debt recovery tribunal DRT বললাম। Against the same, the petitioner preferred an appeal before the Debt Recovery Appellate Tribunal, in short DRAT. The DRAT had allowed the appeal and had remanded back the matter to the DRT for fresh consideration in the light of the observations made by the DRAT.
By an order dated 31st August 2022.
By an order dated 31st August 2022.
22.
Please stop. DRT on remand had heard the petitioner's application under section 70 afresh and dismissed the same by an order dated
2nd December 2024.
2nd December 2024. The petitioner says that all on a sudden the
No, my lord, then thereafter preferred an appeal before the DRAT.
sorry.
Before that, we have made an application to be.
The petitioner then the petitioner challenged the order of dismissal dated
December 2.
by filing an appeal before the DRAT.
On 16 January 2025, page 25.
On 16 January, the
January
2020. The appeal was out of time. The appeal was out of time.
5 days, yes, my lord.
Was out of time and has been subsequently admitted.
Yes.
But no order, no interim order has been
The
passed.
matter was not taken up, my lord.
No, Milords, may I clarify?
Take the diary now.
Milords, it's not admitted, Milords, because
Oh.
delay is not condoned yet.
Is out of here.
Out of time
And the condonation application is pending.
And as such,
My lord, kindly.
it is pending at a pre-admission stage.
Yes. Page 28 of my supplementary, it is there. PO is on leave.
no interim order has been passed by legal government.
কোনটা? না।
And the appeal was out of time and as such, it is pending at a pre-admission stage.
Pre-admission stage. In view of the delay. তারপরে it appears from the record that during it also appears from the record that between the dismissal of the section 17 application and filing of the appeal, the bank had made an application under section 14 of the before the concerned ACJ.
Yes, yes.
On 2024.
On 12th,
2024.
20th December.
on 20th December 2024. Full stop. It is the case of the petitioner that the presiding officer of the DRAT is presently on leave, and as such, the same is not
Same was adjourned.
And the and
Page
as
28.
and as when was it adjourned?
Page 20. Just a second.
My lord, this is 22nd
Malad,
May.
That was, my lord, 22nd May when the matter was first placed before the chairperson. PO is on leave. Matter is adjourned to 29 July 2020. My page 28.
কি বললাম?
It is the case of the petitioner, the presiding officer of the PRAT is presently on leave, and as such,
When the matter was
Placed before the chairperson.
And as such, when the matter was listed on 22nd May 2025, the same was adjourned till
29th July 2025.
29 July 20.
On the ground, PO is on leave.
The petitioner says that immediately thereafter, the bank, by obtaining an order under section 14, has attempted has disposes the petitioner
Partly, my lord, not full. Partly. Still, I am possessing.
as partly disposes the
Yes.
petitioner,
Only, my lord.
partly disposes the petitioner, and has handed over the property to the auction purchaser. The auction purchaser is represented by Mr.
Ayush Mitruka, my lords.
uh,
My lords, will give a slip.
yes, is represented by who is his junior? Is represented by Ayush Mitruka, assisted by instructed by Sujit Swam. Appears and submit that a valuable right has accrued in his favor by way of auction purchase, as also on the possession having been made over to him.
Sale confirmation has not been made.
Sale confirmation is not required.
No, my lord, sales certificate was given to me 2019.
Sale certificate is enough,
Sale certificate, my lord, deed of conveyance cannot be executed.
not required.
Not required. Supreme Court has said not required.
After the bank position will be.
That is Mr. Chaudhary.
Malad,
That is the catch. In case of bank sale, no deed is required. The certificate is
sufficient.
Subsequently under the Stamp Act.
But subsequently they will execute.
No.
They cannot. This is the reason they cannot execute the deed of conveyance because the possession has to be delivered. They cannot.
Whatever.
Yes.
I'm not going on to it.
Yes.
So auction purchaser is represented by such and such. Players and submit that a valuable right is accrued in his favor by the auction purchase, as also on the possession having been made over to him.
It is also submitted by the auction purchaser and the bank that the entire possession of the land has been taken and
We are in control and possession, my lords, today.
Has been taken, and the auction purchaser is in complete possession of the complete land.
Kindly record my online.
No, yeah, I have recorded that.
That entire 5 acres of land, it is.
Full stop. Responding to the possession to the issue of possession, it is submitted by the petitioner that there is no boundary demarcating the land, separating the land from other adjacent land, and as such the petitioner is still in possession of a portion of the entire 5 bigger land. Full stop. It is also the case of the petitioner that growing crop, tools, tackles, and other equipments for cultivation has been lying at the said land, and as such the same could not have been attached in execution of a decree in view of the provisions of section 60 of the Code of Civil Procedure 1908 CPC.
Yes.
It is also the case of the petitioner that the land in question, being an agricultural land, could not have been charged in favor of the bank for creating a security for availing a loan in view of the provisions of section 31 of the Services Act.
Milord, we have disputed that.
Be
Milord,
that
we have disputed that.
this submission is also disputed by the bank and the auction purchaser.
Great.
Be that as it may, the auction purchaser, if not a necessary but a proper part, the bank has already taken a stand that it has obtained an order under section 14 of the Services Act and has handed over possession of the same to the auction purchaser. It is therefore the possession of the land, if any, with the auction purchaser has to be defended by the auction purchaser. The auction purchaser, therefore, give the particulars.
Please, my lords, we'll give that, my lords, the
The
details.
auction purchaser, being so and so, is added as opposite party number 3 in this civil in this revisional application. A copy of the application be served on the auction purchaser and or his advocate, he or she.
Milords, it's an LLP.
It's advocate. Full stop. It is a fact that the application of the petitioner before the DRAT was adjourned on 22nd May 2025.
July.
Adjourned on
Milord, 22nd May,
till
29 July.
in absence of due to the absence of the presiding officer of the DRAT. The petitioner cannot be left remediless in such a situation, and as such, this matter is required to be heard. Let this matter appear on.
Any day, your lordship's conveniences.
Let this matter appear on
Monday,
Friday.
day after tomorrow, Milord.
Yes, my lords, may keep it on Friday if that's convenient to your lordship.
Milord,
Very well, Monday, full stop. However, the parties are directed to maintain status quo as on date in respect of the plot of land, the particulars whereof are more fully described in the
Application, revision.
in this application till 18th 18th June 2020 2025.
Milords,
The order of status quo is required as any alteration of the nature and character of the land or its possession during the interregnum will render the revisional application infructuous. The maintainability of this revisional application as raised by the bank and the auction purchaser is kept open.
Can you know?
Milords, your lordship may give on transfer,
No,
Milords. Status quo, Milords, will be a far-reaching order when your lordship has not even decided maintainability. Milords, that's my submission, Milords, for your lordship's consideration.
See, today the status we do not know what is what. How
Milords,
can
precisely, Milords, this will give rise to more litigation, Milords, tomorrow. And Milords, kindly look at the conduct, Milords. That order was passed in April. They are coming in June. Milords, the PO was
very well.
leave for 1 day, Milords. 1 day he
Very-
was on leave.
Very well. Take the ওইখানটা স্ট্যাটাস কো না পড়ে কথা কি বললো?
However, the parties are directed. to
ওখানে
maintain-
করে দাও ওখানে কি কি সেন্টেন্সটা আরম্ভ করেছে?
However, the parties are directed to maintain status quo.
ওখানটা কেটে দাও in the aforesaid facts and circumstances the bank and the auction purchaser are restrained from dealing with, disposing of, or changing the nature and character of the
Milords,
land.
Milords, transferring, Milords, not nature and character is status quo, Milords. All I'm requesting is your lordship may restrain from transferring.
Sorry.
And there was a purpose of the bank and the auction purchaser are restrained in dealing with the disposing of the
Dealing with, disposing of, and or changing the nature, character, and possession of the property in question. The particulars whereof are more fully set out in the application. Till হচ্ছে 18th বা 19th করে দাও. Let this matter appear on
Monday.
Supplementary
Supplementary affidavit can be taken on board.
and be sub.
উপরে দিয়ে দাও একদম উপরে সাপ্লিমেন্টারি এফিডেভিট এই কপি আছে যেখানে
taken on record.
record a copy of the supplementary affidavit along with the petition shall be served in course of the day
Already served.
or to the auction or to the added
I'll do that.
to the opposite party number 3 added by dint of this order. আর ওইদিকে হচ্ছে in course of the day, ঠিক আছে?
Yes.
আর ইয়েতে copy one is already
Copy served. Affidavit of service also taken on board.
very well.
Grateful, Milords.
Affidavit of service.
Huh?
Affidavit of service.
ওই উপরে দিয়ে দাও affidavit of service.
এটা নেই। Grateful. Sorry, my lord, I have taken a much time, my lord. It is about to one. My lord, certified copy shall I file in the department?
Yes, certified copy ইয়েতে
Or
ওইখানে দিয়ে দাও the petitioner is directed to file the certified copy
today itself.
placed before the court certified copy of the order impugned,
Which we obtain leave.
placed before the court in the department for being put into the record.
Yes. এটা আমাকে দিন। হ্যাঁ। Let's item number 8, kindly fix on Friday.
Which one? Item number 8?
8 actually. Today, item number 8. Kindly fix on.
Why? Item number 8? I was hearing you.
No. Hearing no. Fix on today.
Why?
So tomorrow I will go for my medical. That's
Everybody is going for medical treatment.
My lord, kindly. That's why if call in tomorrow is coming, I cannot have
Where is your other side?
the side.
Who is your other side? Very well, let it, you ask your junior to.
It is.
No. In this manner, it won't be done. You are appearing for the other side.
Yeah.
Who?
I know.
Let this matter remain in the list. Ask your junior to mention when it is called on tomorrow.
Okay.
Item number one. Under.
Senior counsel Mr. Partha Ghosh is appearing virtually.
Yes.
Mention. Item number one. Item number one. Under the heading there in connection with appeal.
Yes, who is appearing virtually?
Senior counsel Mr. Partha.
এগুলো কি তার একটা গেঞ্জি পরা ছবি দেখছি। Yes, pass over, pass over.
Item number two.
Lordship, in item number 2, I am appearing on behalf of the petitioner. This matter is being led by Mr. Counsel Ajoy Devnath. Would be very grateful if your Lordship kindly fix this matter on Friday, as because under the instruction of the senior counsel, Mr. Devnath will be appearing in person for this matter.
Application for condonation of delay. Application for condonation of delay.
What can be done? For how many days delay?
Not 300 something, but
Who,
351 days.
whose application? Their
Their
application. So they are asking for time, what can be done?
Very grateful.
Lord, as the Lordship directed yesterday, Lord, my junior contacted the advocate on record. And Lord, she said that she has just lended her name. The matter pertains to her senior, and thereafter Mr. Ajay Devnath's clerk contacted me and said that they will appear. But now you are going for them.
Very well, Friday when.
Mark. Great.
Item number three.
Lord, I am for the state.
Item number three.
কি করবে দেখো এই মিটিং যখন হবে বারের সঙ্গে তখন বুঝতে পারতো, তখন বলবে হিয়ারিং হচ্ছে না, আর এই তো অবস্থা হিয়ারিং। এটা কালকে অ্যাপিয়ার করেছিল?
Yes, Lord. In the list yesterday.
কালকে পুরো লিস্টটাই কল হয়েছে, অ্যাপিয়ার না করার তো কোনো ইয়ে ছিল না।
পাপাই মোহাম্মদ, অ্যাডভোকেট অন রেকর্ড।
So Vishwarup Roy, my lord, was present yesterday.
Oh.
But yesterday, since the judgment was given to me, my lord, after 9 p.m. at night, I was not ready yesterday. Today I am ready, Lord. I've gone through the papers. But today
So whether he is available today
I seen
in
him
bench?
this morning, my lord. He was good.
We are passing it over, informing.
My lord. Grateful.
Item number four. Under mandamus appeal. Item number four.
Item number 4, my lord, Ms. Mosme Bhal is appearing virtually.
Who?
Mosme Bhavel.
Oh. Yes, anybody is appearing virtually. Mousumi Bhawal.
No.
Yes, who is for the respondent? State is the respondent.
My lord, in item number 4, my lord, I am appearing for the DPSC Kujbihar led by Mr. Omolesh Roy, my lord. My lord, the copy has not been served, my lord.
Who is for the petitioner? I'm unable to find, we are unable to find the petitioner.
Oh, my lord.
কি হবে pass over.
Your lordship kindly make it not today, my lord.
Yeah, we cannot do so because the other side is not there.
Item number five. Under mandamus application. Item number 5, refer to respondent.
Restoration.
Mr. Subhranshu Pandey, sir.
Yes,
Refer to respondent.
what is the matter about?
Restoration.
Restoration.
189 days delay.
Appeal
My
can
lord,
be.
my lord, item number. My lord, I am appearing on behalf of the appellant. My lord, this is the restoration application, but it was dismissed for default on my lord 9 January 2025. My lord.
Tell us, appeal can be restored.
My lord, application and my lord, appeal both are, my lord, it has been dismissed for default.
No, can the appeal be restored?
Yes,
Is there any provision for restoration of the appeal? You are traveling in a car or a train?
my lord.
Do you have a code of civil procedure with you?
My lord, right now, my lord, I am it's a difficulty because I am, my lord, going to my native village. That's why, my lord, emergency. That's why, my lord, I could not, my lord, appear, and my lord, I could not bring the all books also. My lord.
CPC টা কোথায় গেল?
Order 41, Rule 19,
Yeah.
readmitted.
Readmission of appeal, order 41, rule 19. It is readmission of appeal, not a restoration.
But then, my lord, my lord, paying for apology, my lord. Then, my lord, readmission, my lord.
Yes, what do you say about the delay?
189 days delay. Well, the dismissal order was passed way back in January 2000.
January
2003.
25. No, are you seriously opposing?
Up to
No.
That is 189 days.
See, if you are seriously opposing, then I have to grant you an opportunity to file.
I'll leave it to you first.
This is an application
Can you restore?
for the appeal being readmitted and the connected applications being restored to its original file and number after recalling the order dated
January 2020.
9 January 2025, by which the appeal and the connected applications were dismissed for default. Although the grounds cited for the delay in making the application are not convincing, and to some extent, the learned advocate for the respondents is correct that the petitioner was not diligent. But for the ends of justice, the appeal is readmitted and the
Preparing the application for
by condoning the delay, most of the connected applications are condoning the delay and recalling the order dated such and such.
Right.
The connected applications are restored to their original record to original file and record
original number.
Origin. ঠিক আছে? So, the application being such and such is accordingly disposed of. Let the appeal be placed before the, along with the connected application, before the next circuit bench, subject to its convenience.
Deeply obliged, Your Lordship. Grateful.
Paper books are already,
No, my lord, no, my lord. In the motion state, it was dismissed for default.
Yes.
Deeply obliged. Grateful. My lord.
Item number,
Item number 6, I beg to appear on behalf of the petitioner, Lordship. Appellant, Your Lordship.
Yes,
I beg to appear on behalf of the appellant, Your Lordship.
what is the matter about?
Lordship, this is a matter in which stay was granted on to us on the first date of hearing, Lordship. Where is the? There was a direction upon the respondent authorities to file an affidavit, Lordship. Which
Who
is
is
not,
the respondent?
Lordship, respondent state is a respondent.
Mr. Shah, State Union of India and others.
State Council, the uncle expired. He will be available on.
Unable on?
The uncle expired.
No, that he will be available on a particular date. Where is the affidavit?
The out of station and roughly goes to contract. And let the matter take on.
Mr. Shah, is it your case that the council's uncle has expired, so he has gone to his uncle's place with the affidavit?
No,
Then where is the affidavit? It must be with on record with him. Very well. When is he going to come back?
Monday.
Tuesday রেখে দাও এটাকে।
ফাইল বার কর সম্পর্কে থাকতে বলো ফাইলটা বার কর
কি হচ্ছে ভাই? এটা কে ঢুকে বসে আছে?
সিনজাংশা নিয়ে
item number 7.
Lordship,
Yes.
Lordship, in this matter, I am appearing for the appellant. Lordship,
Who
the
is for the
subject matter of the
respondent? Who is for the respondent?
Lordship, I have on 21st, last month, 21st day of May, I served the copy upon learned additional GP.
Additional? GP. Mr. Shah.
Because all are state responded.
Mr. Shah. As usual, state is in an unready, defective.
No, already defect cured by my learned junior as yesterday, day before yesterday matter appeared before your Lordship.
Yes. What is the matter about?
The matter is about the police inaction. Lordship, in the matter, the petitioner before your Lordship, he is a 66 years old senior citizen who lost his 80% vision due to retina problem and having with 76 stitches in his body. Now he is the sole legal heirs of his parent, being an only child. I'm telling the facts, Lordship, then I'll come. Now he inherited the entire property of his parents after their demise. Now, subsequently, on 14th day of February 2025, while he had been to his one land, having with 50 decimal with 9 plots number, out of 9 plots, 8 is agricultural and one is residential for construction of his new house, because in the meantime he has been thrown out by his son from his own residence situated within the Kochbihar town at municipal ward number 5. He is forcibly evicted there, and therefore he had been to the land to bounded the land to complete the boundary of the land. And because in the meantime, 3 sides of the boundary has been completed. Suddenly, in the midst of said work, his son with the antisocial had been to the land and threatened him, and physically by using force thrown out him in the middle of road, which is situated in front of the said road. The petitioner then went to the local police station on 22nd of February and lodged his written complaint, and thereafter it is forwarded to the SP, Kochbihar. Now thereafter, due to inaction on their part, the petitioner moved a writ petition wherein the honorable judge has been, single bench has been pleased to dispose of the writ petition by saying, or relying upon a report of the police authority, by saying that the matter is disputed, dispute is civil in nature. Lordship kindly noted there are two parts of land. One is residence, one is agricultural land, for which he sought at the posting of additional police guard. Now in the residency, regarding residency, lodged a complaint that it is criminally caused after evicting him, it is criminally converted by them. Now subsequently a report has been submitted. Lordship kindly come to the order of the honorable single bench, page 14. Page 14, your lordship will find that relying a report of the officer in charge Kotwali police station dated 6th January 2025. The matter is, but my complaint is lodged on 15th February, 22nd February, not 6th January. How it is possible? So without giving, even the copy was not supplied, and matter is now subsequently after that petitioner inquired and found that one fraudulent deed has been executed in respect of the residence, not the other land for which he paid for police posting, lordship, police guard.
How,
So,
how is it a police inaction matter? It is a complete civil matter.
No, lordship, kindly say regarding the land which I am bounding, I being in the only son, there is no dispute, there is no title deed, other title deed has been executed, nothing else.
You file a civil suit. File a civil suit.
Lordship,
Get an
kindly
order
see
of
the
injunction.
report of the police authority.
Sorry.
Report of the police authority.
No, it's not. See, police authority, can the police decide the title? Whether you are having it or whether you are having
regarding
it
the part where I want to posted the police guard, there is no civil dispute. Civil dispute is relates to my residence. So I am not on that. I am not on that. Only to complete my boundary wall, because report I lost complaint on 25th February, 22nd February, and they submitted a report dated 6th January 2025. How it is possible?
We do not find any infirmity and perversity.
Relates to the landlordship, my residential house, I can go for civil dispute because one title deed is there. Rightly or wrongly, one title deed is there.
Eso. This intercourt appeal arises out of an order dated
30th April 2025.
30th April 2025, by which the learned single judge dismissed the petition filed by the appellant on the ground that
Dispute between the parties.
On the ground that there are internal civil disputes between the appellant and the private respondent.
না রেসপন্ডেন্ট করেনি প্রাইভেট রেসপন্ডেন্ট
এটাই দেখতে চাইছিলাম।
and his son.
And his son, for which কি বললাম তোমাকে? And his son, for which police interference is unwarranted. Full stop. After hearing the parties and considering the materials on record, we do not find any infirmity in the order, as the same relates to dispute between the appellant and his son in connection with immovable properties, in respect of some of which the appellant is seeking to raise boundary wall with police assistance. We are, therefore, not inclined to interfere with the ordering to the appeal, and the connected application is accordingly dismissed.
No,
Only one thing, Lordship. The report which is submitted, let me supply the copy of report, because otherwise I can't know what report they have submitted.
To go before the civil court, ask for the report. আর ডাকবে আমরা 41টা তাহলে ওই অ্যাডমিশন গুলো তো ওই দুটো পড়ে এসে করবো। আগে পাস ওভার গুলো ডেকে নেবে, ঠিক আছে, তারপরে অর্ডার 41
Because in this matter, not will be coming. Physically will be through the not Monday. Then you will speak down. Morning, your
করবে কলকাতা থেকে আসবে ভেরি ওয়েল মানডে
password matter item number 3. But I'm going to say. I'm the active.
What is the matter about? Bail.
I wear 2 months stand up. Here, it's going to be. NCR is saying.
Only count long incarceration, only.
One eyewitness was it? Although it is a contradictory, their statement during investigation and trial, and also there is no motive loss.
Like, motive is an additional link. Motive lies hidden in the mind of the perpetrator of the offense. It is manifested through conduct. Proof of motive is always not essential. Life.
Did you take the assailant in court as well? Lord, she has clearly stated, Lord, as to how the entire incident took place. And Lord, the clear-cut case of conviction, Lord, and as such, Lord, no case for bail is laid out at this. Lord, I have cited one charge against the lordship.
We have dealt with it. We took the pen to deal with the matter. You cited Calcutta.
2020.
Yes.
Rahul.
Not
No,
that.
no. 2007, 11 SC, 2011, 7 SCC.
21.
No. Difference between 389 and 439, 2007, 11 SCC, 639 or 649.
But I stand corrected, it's 2020.
20?
2028 is 61. There are 35. A case for bail is made out at this particular. And it's made to fix out the show.
Pritpal Singh. This is an application under old act.
New act. 430 of BNSS.
Acha. 430 within bracket 3
Of BN.
of BNSS for bail in connection with an appeal CRA within bracket DB 22 of 2025. Stop. The appeal challenge the judgment of conviction and order of
Appellant has challenged.
appellant has challenged actually. Judgment of conviction ডেটটা বার করছি আমি dated দুটো কেন 20th/21st day of December, oh, 20th December 2023 and 21st December 2023.
কবে ফাইল করেছেন?
হ্যাঁ,
ফাইলটা কবে
হ্যাঁ।
করেছেন?
ফাইল
20 তোমার ডিলে ছিল না
ফাইলটা স্ট্যাম্প থেকে
ফাইল ইন 2025 মিলন
ও হ্যাঁ
ডিলে was conduct with
আচ্ছা বললাম তো কমা দিয়ে হয় ভাই দ্য petitioner the applicant has been held guilty for commission of the offense punishable under section 302 slash 324 of Indian Penal Code and sentencing the applicant to suffer rigorous imprisonment for life with fine of rupees 20,000 and for commission of offense punishable under section 302 তাহলে ওই ভাগ করে দেবেন বুঝতে পেরেছেন হ্যাঁ ওপরেরটা দিতে হবে না and also for and to suffer rigorous imprisonment for 2 years with fine of rupees 1,000. Stop. Mr. Roy, learned advocate, repenting the applicant submits that petitioner is in custody since last 5 years.
Over 5 years.
More than 5 years. For more than 5 years. He submit taking note of long incarceration of the petitioner. He may be admitted to bail. Stopped. He also submits that there is a fair chance of success of the petitioner in the appeal. Stop. Achha, Dr. Chaudhary, learned
No,
advocate.
he has also pointed out the discrepancies.
Achha, he has also pointed out certain discrepancies in the evidences. His point he has claimed that there are
certain discrepancies in the evidence
which has rendered the prosecution case unbelievable.
There is no chance of immediate
And there is no likelihood to disposal, expeditious disposal of the appeal.
See, we were thinking of after the permanent building is made operationalized, that if the number of judges here are more, then criminal appeals can be taken. Otherwise, we were thinking alternatively let this appeal hearing go before the principal bench. Otherwise, what will happen? Every now and then, the matters will be listed in the circuit and ultimately it will not be.
কোথায় নামলাম ডক্টর চৌধুরীতে নেমেছি আর ডক্টর চৌধুরী learned advocate repenting the state submits that the prosecution has successfully proved the involvement of the present petitioner in the alleged offense, and he submit that there is a direct eyewitnesses who identified the petitioner on dock and has presented the evidence, substantive evidence against the present petitioners. Stop. He cites a decision reported in 2020, volume 8 SCC, page 645, within bracket Prithpal Singh versus State of Uttar Pradesh, for the proposition that there is a distinction between the grant of bail under section 439 of the Code of Criminal Procedure, in the case of pre-trial arrest and suspension of sentence and release of bail under section 389 of the CRPC at the post-conviction stage. He further submits that
Which is now 430.
Corresponding to 430 within bracket 3 of BNSS. He submits that at this stage, the court must consider whether there is a strong compelling reason to grant bail to the applicant or not. Stop. Had the learned advocate peruse the materials on record and the judgment of conviction and order of sentence. Stop. আচ্ছা admittedly there was a direct evidence which
On the basis whereof
on the
the-
basis
whereof
whereof
the
the
applicant had been convicted.
Stop. আচ্ছা ঠিক আছে, we do not find any compelling reason. We do not find that we do not find that the petitioner has not been able to make out any strong compelling reason to obtain an order of bail. Stop. Mere long incarceration in the custody cannot be the ground.
Upon being convicted.
Upon being convicted, cannot be the ground to enlarge the petitioner on bail. Stop. Therefore, the application for bail is thus. Therefore, we are not interested to application of bail of the petitioner
We are not inclined to entertain
at this stage.
application for bail
আচ্ছা
at this stage.
আচ্ছা ওনাকে একটা বলে দিন অল্টারনেটিভলি হি মেড আবার আচ্ছা the state is directed to here LCR has been called for.
But yes, during admission only, Lord, that direction is usually passed.
The direction has been given.
Paperwork?
Paperwork has not been prepared. Acha, we have been informed that the TCR has been called for. Stop.
এইটাকে না ওই আগেরটা তো হচ্ছে অ্যাপ্লিকেশন হলো, এটা হচ্ছে
অ্যাপিলে করবেন। আচ্ছা স্টপ। আচ্ছা office is directed to expedite the preparation of the paper book. Stop.
Parties will be at liberty to mention
for enlistment of the matter immediately after preparation of the paper. ঠিক আছে?
Great.
Item number 4, password matter under manual snapping.
What should request for getting this one sometime next week, because the supporting an application has not been filed, only the memo of appeal is there.
what is the supporting can application?
Along with the copy of the written petition and only the memo of appeal in this matter has been filed, it's the supporting can application that has not been filed.
Very well. This is a mandamus appeal. The records are already there.
I will require an order. Was passed.
My lord, I am appealing for the DPSC Kujbihar, my lord. My lord, the copy of the memo of appeal has not been served, my lord.
Memo of appeal is not required to be served at this stage.
Yes, my lord, I don't know whether the application for stay has been filed or not. No documents have been served, my lord. And my lord, in pursuance of the order, my lord, the order of transfer has already been issued by the council.
already issued by the council.
Yes, my lord.
So anything remains in the appeal.
My lord, because the order has already been implemented. My lord.
Even before the report, what happened was, because I was a senior assistant teacher working.
Where?
Because I was working in the school. It's called Kala Barighat, fourth plan primary school.
Where?
In Kuchbihar. Now, I was put under what is said to be a stopgap arrangement kind of a transfer. Now, my request before the report was four. First was that I was the senior most teacher, and if I am transferred, then the student people ratio in the school gets zero, and therefore I shouldn't be transferred. The second request was not that the headmaster also is written in my favor that I, being the senior most teacher, generally perform the duties of a teacher in charge, and therefore I should not be transferred. Third was my medical condition is not permitted. I have annexed medical documents and everything along with the reports. And the fourth contention was that even before, because I was transferred on a stopgap arrangement. So generally, it is the junior teacher who are transferred, and therefore I shouldn't be transferred. Based upon that, I preferred a repetition before the honorable court. The court by way of an order, so my transfer order was already there when the repetition was there. The court by way of an order of May 2025 has refused my papers and challenging that before my lordship.
Yes.
Now here my lordship only the memo copy is there.
Have you joined at the transferred place?
No, my lord, she has not yet joined. No.
When shall you join?
Because without prejudice, that adds then I will join.
Admittedly, you are a surplus teacher. You are a surplus teacher. You didn't contradict the submission made by Mr. Roy that you are a surplus teacher.
Now, as on today, it may be a surplus position, but upon transfer,
No. Surplus or no surplus? Your job is a transferable job.
First.
Now, in case of transfer, in service jurisprudence, what is the scope of resisting this thing? Unless the transfer is arbitrary, unless the transfer is aimed
punitive measure.
As a punitive measure to victimize you,
First.
or it otherwise is detrimental to the interest
First.
of the organization. Otherwise,
Second point, because previously also I was transferred for continuously 4 years and 5 months, and then again within a span of 2 years, this sudden transfer order stopgap arrangement has taken on. Whereas generally, the junior teacher who are transferred, not the senior most teacher of the school.
there are two ways. One is suppose you are teacher in X category. You are a primary teacher, so probably there is no subject thing. Now, in case of secondary teacher, subject. So suppose there are 3 Bengali teachers. Now, one can always be transferred because it's the policy decision, administrative domain. The court does not interfere into that. Now, you say that I should not be transferred. To make out the strong grounds in your favor, you have to show that the transfer order is arbitrary or it victimizes you.
First.
What are the ingredients?
Yes. Because I was previously also transferred, and then the second transfer that is coming.
Maybe.
And my medical condition was very serious. I have a issue, it's a servonuclear disease, wherein I have a problem keeping balance of the body.
Very well.
So this
Same circle. You have been transferred in the same circle.
My request to be, without prejudice, let me allow to be joined in the transfer school.
See,
But let the application.
you have, no. You have filed an appeal. Even if you do not file a stay application, the appeal can be heard. Now,
Based on the memo of the
appeal can be heard. So let us look into where is the infirmity in the order.
But was the copy of the revision no. My lord, I always should take information in the order, but the copy of the
It is an intra-court appeal. The writ petition is in the department. We can call for it any time. Where is the question of filing paper book and these things? If we do not find that the appeal is otherwise not required to be entertained.
Yes.
So show us, show the infirmity in the order.
When my lordship, I find the writ petition, along with the writ petition, there were, 5 grounds that were taken in the writ petition. The first ground was not my poor health condition, and in support thereof, there were medical documents from page 18 to page 34 that were annexed along with the writ petition. The second ground was not that there was no consultation that was done with. The third
Is it required?
One thing is.
Third ground also is important. That is not that there was a skewed teacher-student ratio. Why I said so, lords? Because there were in total the required ratio, lords, was one.
Is it your lookout? Whether the teacher-student ratio will diminish.
The Right to Education Act provides for a certain teacher-student ratio.
That is
Headache of the administration.
that is within the administrative domain. Can the court go into? Will we start monitoring that which teacher will go in which school or which high school? It's not possible.
In order to fill up a vacancy of a different school, if the teacher-student ratio of this school gets skewed, then what?
Whether there is any surplus teacher other than you.
There is a surplus.
A surplus, if more than one surplus teacher, you can say that send my junior.
Yes,
One
of them is going to be.
How many are surplus teacher? No. Question is whether there are any other surplus teacher or not. In that case, you can say they'll let the junior go, senior will be retained. Join.
And thereafter, the teacher-student ratio further gets skewed up.
Join.
Take down. The appeal arises out of an order dated. Now, this intra-court appeal arises out of an order dated 13th May 2025, by which the learned single judge dismissed the writ petition wherein the appellant disposed of the
refused to accept the petitioner contention to.
It was a bad case.
Wherein the appellant had challenged his order of transfer. The appellant is an assistant teacher at Kalabarighat 4th Plan Primary School
A 7 mile circle.
in under 7 mile, SATMILE
Circle.
in the district Kuch Bihar. The appellant has been served with a memorandum dated 21st April 2025, by which he has been transferred to Khorija, Kharija, Nal Dhondra, NALDHONDRA, fourth plan primary school under the same circle as a stopgap arrangement. Appellant says that he is the senior most teacher in the school and is often
suffering from certain
and is often performing the duties of teacher in charge. The appellant is suffering from serious neurological disorder.
Cervical spondylotic radiculopathy.
What to be?
He's suffering from
Cervical spondylitis.
Moreover, the teacher-student ratio on the appellant being transferred will be will become disproportionate.
Yes.
Will become disproportionate, as a result whereof the action will be action should be construed to be an invalid one. After hearing the parties and considering the materials on record, we find that there is no bias or iota of victimizing the petitioner by way of transfer. The transfer, admittedly, the petitioner is in a transferable surface. The petitioner has been transferred.
Surplus teacher.
The petitioner,
circle.
The petitioner has been found to be a surplus teacher in the concerned school, and as such has been transferred within the same circle as a stopgap measure. Ordinarily, transfer of an employee is left to the administrative domain and is seldom interfered by the court. And is interfered by the court, seldom court, and is interfered by the court only under limited limited conditions. This is so as transfer is aimed for effective administration and therefore falls within the policy decision of the employer and or the administration. We do not find any limited ground on which the court can interfere into an order of transfer has been made out in this case. We also do not find any infirmity in the order of the impugned. In the aforesaid facts and circumstances, the appeal is
should be transferred as a permanent teacher, should be transferred as a permanent teacher. You mentioned stopgap arrangement is not appreciated.
কি বললাম আচ্ছা এই ওইটা উপরে চলে যাও যেখানে স্টপ গ্যাপ বলেছি না ওখানে ওইখানটা একটু পড়ো তো
The agreement has been served with the memorandum dated 24th April 2025 by which he has been transferred to Kharija Court Plan Primary School under the same circle as a stopgap arrangement.
না না
Next stop.
না ওখানে স্টপ গ্যাপ না ইয়েতে has been transferred to খরিজা ওখানে
স্টপগ্যাপটা কেটে দেওয়া
স্টপ গ্যাপটা কেটে দিন ওখানে একটা ইয়ে দেন তারপরে পড়ুন ওখানেটা কেটে দিন তারপরে পড়ুন
Stop. The agreement says that he is the senior most teacher in the school and he's often performing the duties as teacher in charge.
ওটা তো ওনার বক্তব্য বলছে
ঠিক আছে
জাস্টিসের ইয়ে অবজারভেশন
Found to be a surplus teacher in conference school and as such has been transferred within the same circle as the stopgap unit.
No, we can as we transferred within the same circle in another school. Full stop. ওখানে একটা add করুন. Although the petitioner, although the appellant says that his transfer is as a stopgap measure, but we find from the order input that the learned single judge, after considering the materials on record, has found that he has been transferred as a permanent teacher.
He should be transferred.
Order was for stopgap, the learned single judge without right there converted it into a permanent.
ঠিক আছে কি বললাম
He has been transferred as a permanent teacher.
না although কি বলছি although
What we find from the order input that learned single judge, considering the materials on record, has found
has directed that
It should be transferred on permanent basis.
the petitioner should be transferred on permanent basis instead of a stopgap measure. ঠিক আছে তারপর যেখানে ছিলাম সেখানে চলে যান
Is the appropriate facts and circumstances the appeal
appeal is dismissed, upholding the order of the learned single judge.
My lord, one submission.
Yes.
No submission.
Terms of that order, my lord, the petitioner has already been, my lord, transferred, my lord, permanently, my lord, by wide order dated 3rd June 2025, my lord.
ঠিক আছে ওখানে কি বললাম in the aforesaid facts and circumstances আগে একটু ইয়ে করুন it is also the case of the respondents. Your respondent number
4.
I'm asking for the DPSC could be a respondent number 4.
It is submitted by the respondent number 4 that in terms of the order impugned, the a fresh memorandum has been issued on 2nd June,
3rd June.
on 3rd June 2025, by which the petitioner has been transferred to the same school or on permanent basis instead of a
Temporary.
stopgap measure. Full stop. এই তারপর যাচ্ছিল তাই অ্যাপ্লিকেশন তো কি কিছু নেই
না না শুধু অ্যাপিল ওকে অর্ডার 41
Item number 8, under order 41, rule 11. Item number 8.
কেউ নেই
Item number 9. Item number 9.
এইটা কোনটা বলো তো এইটা
এইটা ডায়েরি ম্যাট্রিক ছিল সোমবার দিন আর এটা আবার
হ্যাঁ
এই যেটা বলবো
দেখো তো ওই লেডি অ্যাপিয়ার করছিল কিনা
হ্যাঁ স্যাট সেকেন্ড অ্যাপিল না না ওটা তো 8 নম্বর হ্যাঁ
যেটা টপে
8-এরটা তো কেউ নেই পার্থ ভৌমিক কেউ আসেনি আর স্যাটটা সেকেন্ড অ্যাপিলটা লাইনটা আমাদের কাছে পড়ে না ডিসমিস করাবো পরে রেস্টোর করি অন্য বেঞ্চে করি হ্যাঁ বুঝেছি এই সেই টেন ফেনোগুলো বয়াতে পারবো না বাবা, এভিকশন চাই?
করবে বলতে এভিকশন সুট, ল্যান্ডলর্ড।
এভিকশন নয়, ডিক্রিয়েশন অ্যান্ড পার্মানেন্ট ইনজাংশন।
হ্যাঁ,
মানে সাবলেটিং এর কথা বলছি, আর বলছে অ্যাডিশন অল্টারেশন, কিন্তু এভিকশন চাই। এবার সুটটা ডিসমিস করেছিল, অ্যাপিল কোর্ট ওই পার্মানেন্ট ইনজাংশনটা দিয়েছে। ভুল কি করেছে? আইনি বলা আছে সাবলেট করবে না, হ্যাঁ, বা অ্যাডিশন অল্টারেশন।
ওই কেসটাও তো বলেনি যে ও তালা বন্ধ করে রেখে দিয়েছে মোর দ্যান 10 months।
ওটা বলি ডিসমিসটা বিকল্প দিয়ে আসবে প্যারিস থেকে।
দেখি,
লাস্ট
এসো।
1 মাসেও আসেনি। আমি বলে সামটাইমস কোশ্চেন অফ ল নট ইম্পর্ট ওদের টেন্সে বললাম বলে দেন তাহলে
Actually, দেখো না, actually, I can, which means the appeal will go.
হ্যাঁ 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 অর্ডার 41 সামানালি ডিসমিস করা যায়
ইলেভেন টুতে দেখুন।
ডিসমিস ইয়েস যদি আমি ওয়ান এর ডিসমিস করো তখন আমি ডেট ফিক্স মানে পড়ে যাবে
ডেট লিস্টে আসছে মানে তো ডেট ফিক্স।
ডেট ফিক্স হয়ে যাবে ডিসমিস ফর ডিফল্ট করা যায় বা
ডিসমিস করে ইট অন মেরিটস।
হ্যাঁ নো সাবস্টেন্সিয়াল কোশ্চেন ইজ ইম্পর্টেন্ট সেকেন্ড অ্যাপিল
The second appeal has been placed in the list for admission. কবে কবে অ্যাডজেন্ট হয়েছে এটা? The appeal was called on for the purpose of admission on 9th June 2025 and 10th June 2025, when no one appeared in support of the appeal. Post. Today, also no one appears in support of the appeal. Full stop. After perusing the materials on record and the order impugned, we find that the appellant as the plaintiff, the appellants the রেসপন্ড এটা কি হচ্ছে ব্যাপারটা বোঝাই যাচ্ছে না। হ্যাঁ,
The appellant institute a suit.
না না, এই দেখুন এটা আসুন আপনি।
অ্যাপেলেন্টের নাম হরিশ কুমার প্রসাদ। এখন তো মোহন সে জেটওয়ানি মারা গেছে।
না না, এইখানটায় দেখুন
প্রিডিসেসর অফ দ্য অ্যাপেলেন্ট করে দিতে হবে নাকি? হ্যাঁ,
না, অ্যাপেলের তো মোহন জেটওয়ানি তো আছে।
হ্যাঁ, না, প্রথমে স্যুট ফাইল করেছিল গৌরী শঙ্কর প্রসাদ। আচ্ছা, তারপর ও মারা যাবার পর হরিশ কুমার প্রসাদ সাবস্টিটিউটেড হয়েছে।
হ্যাঁ হ্যাঁ, সেটা দেখলাম।
আচ্ছা, এখন ওই হরিশ প্রসাদ আবার সেও মারা গেছে।
যশোদা শশী ভার্মা।
হ্যাঁ,
হ্যাঁ, কি বললাম? The original appellants filed a suit for
না, প্রিডিসেসর অরিজিনাল। এখন প্রিডিসেসর গৌরী প্রসাদ হচ্ছে অরিজিনাল ওনার প্লেন্টিভ, অরিজিনাল প্লেন্টিভ গৌরী শঙ্কর প্রসাদ।
হ্যাঁ,
এফ স্যুটটা করেছিল।
প্লেনটা কোথায় আছে গো?
প্লেন্ট নেই।
তুমি ওটা পাচ্ছ কোত্থেকে?
এই যে এই অ্যাপিলের গল্প থেকে, অ্যাপিলের যে গল্প ফ্যাকচুয়াল ব্যাকগ্রাউন্ড, এই দুটো অর্ডার শুধু দিয়েছে এখানে।
হ্যাঁ,
ডিগ্রিটা জাজমেন্ট অ্যান্ড ডিগ্রি পাস বাই দ্য ওই ট্রায়াল কোর্ট অ্যান্ড অ্যাপিল কোর্ট। এইটা অ্যাপিলটা ভালো লিখেছে প্রথম।
হ্যাঁ, কি বলুন? না না, the predecessor of the original appellants as the plaintiff filed a suit for declaration and injunction with other consequential reliefs against the defendants respondents and another, namely Domino's Pizza India Limited, which was the Domino's Pizza India Limited, ওটাকে ডমিনোস করে দেয়, ঠিক আছে? The Domino's was subsequently expunged by an order dated 9th April 2012. Full stop. The original plaintiff, namely Gauri Shankar Prasad, died on 6th April 2010 as a result of which Harish Kumar Prasad was substituted in his place and state by order dated 1st December 2010. The said suit
ডেটটা বলবো
was
judgmental deviation 20. March 2016, it was dismissed. Judgment date, judgment and degree date.
Calcutta ডিগ্রিটা পাচ্ছ কোথায়?
ট্রায়াল কোর্টের ডিগ্রি, ওই জাজমেন্টের ডেটটাই ডিগ্রি হয়ে যাবে।
না, না।
আর আমি দেখছি
তো অ্যাপিল হচ্ছে, অ্যাপিল
ওই লাস্টে আছে, এই যে এখানে একদম শেষটা, এই যে এইটা হচ্ছে এই যে
the suit was dismissed by a judgment and decree dated
29th March 2016.
29th March 2016, full stop. The appellants, or the original appellants, preferred an appeal therefrom, which was appeal therefrom before the court of the additional district judge, third court, Darjeeling, which was numbered as OC appeal number 2 of 2016. আচ্ছা, ওই স্যুটটা যেটা হলো না, স্যুটের এটা নম্বরটা পাওয়া যাচ্ছে, দেখো
Suit নাম্বারটা, আদার সুট নাম্বার 10 of 2019.
ওইখানে দিয়ে দিবি যে ফাইলের স্যুট being other suit number 10 of
2019, 2009.
OC suit number করে দেওয়া, full stop, OC suit number 10 of 2009. অ্যাপিলটা দিয়ে তারপরে ইয়ে হলো, প্রেফার অ্যান অ্যাপিল বিফোর ইয়ে আচ্ছা, কোর্টটা হবে সিভিল জাজ, সিনিয়র ডিভিশন, দার্জিলিং, ঠিক আছে? ওই ওসি সুট বিফোর সিভিল জাজ, সিনিয়র ডিভিশন অ্যাট দার্জিলিং, ঠিক আছে? তারপরে হচ্ছে বিফোর ওসি ইয়ে হলো ওসি অ্যাপিল নাম্বার 2 of 2016 বিফোর দি ওই অ্যাডিশনাল ডিস্ট্রিক্ট জাজ, থার্ড কোর্ট, দার্জিলিং, পুস্টা। The appeal has been partially allowed by a judgment and order dated
15 June 2018.
15 June 2018. The first appellate court granted a decree of permanent injunction as against the defendants of the respondents. Full stop. Challenging the said judgment and decree dated 18th June বললাম না একটা?
15 June 2018.
15
15
June 2018. The
Present second appeal has been preferred.
The present second appeal has been preferred. Full stop. We have considered the judgment of the trial court as also that of the first appellate court. We do not find any substantial question of law being involved to entertain to admit the said second appeal for hearing. Full stop. In the aforesaid facts and circumstances, in exercise of the powers under section 100 within bracket 5, read with the provisions of order 41, rule 11, bracketed 2 of the Code of Civil Procedure, we dismiss the appeal.
The memo of appeal, the grounds taken in the memo of appeal suggests that the petitioner, the appellant is equipped by the finding of facts arriving out by the court below based on the appreciation of evidence. The existence of substantial question of law is sine qua non in entertaining an application in admitting a second appeal. We do not find that any substantial question of law is involved in this appeal accordingly.
করে দিও আমি ওটা দেখে আমাদের গালে হাত দিয়ে অবস্থা কি গেল কে কখন আসবে একটা মামলা করবে
Item number 10.
Next,
Next week.
are you in a habitual defaulter in completing the service? Because this is probably the third matter where in your case the service is not complete. My memory is not that fading out. In one matter, as a for the ends of justice, I allow. We were inclined to dismiss the appeal from June 2024, 14th June 2024. In that matter, you had not taken any step. Series of adjournments. Do you recollect that in your matter? Yes, single bench matter. See, single bench or division bench, it's not, it was your matter. The same issue was there. In another appeal, yesterday or day before yesterday, you said you have not filed the Section 5 application. You said it is your matter. You filed the appeal long back, no Section 5 application. Today again, service complete. What is this? Are we sitting in a circuit to be taken for a ride? Wastage of time and energy. Leave aside the cost involvement. The circuit bench was formed to give respite to the litigants of these districts who find it difficult to travel to the principal bench. And now look here, this is the conduct of the advocate and the way in which the litigation is. See, what wrong has the litigant committed in engaging you? He does not know that he will not serve. He has entrusted you with the matter. He has given the fees you asked for. Now, is it his duty to serve the petition? It is your duty. So why should a litigant suffer for the blemish on the part of an advocate? Why should we not put you into task? When did you file the appeal? Month of March. And we are in towards the middle of the June. Yes? No. Have you done anything great by filing the CAN application? Tell me, have you done something great? No, or your submission is that in other matters I do not file the CAN application. In this case, I have at least filed it. You should be, the bench should be grateful to me that I have done this. And now see, where are the respondents? Which district? Kuchbihar district. Now, if we grant you time, we are sure within this circuit, the service will not be completed. What is the matter about? Tell us. Let us look into it. ভাবে ভুলে যাবো, জজেরা ভুলে যায়। মুশকিল হচ্ছে আমার মুখ এবং মামলা সচরাচর ভুল হয় না।
ডিফেক্ট আছে কিছু বোধ হয়, ডিফেক্ট আছে না? ও
ও ক্যান ফাইল করেছে তো।
ও
আমার যে নোটিশ দিতে হবে আদার সাইডকে এরকম তো না, ফার্স্ট হিয়ারিং আমি এমনিও উড়িয়ে দিতে পারবো। দেখি শুনি না কি গল্পটা আছে, কেন এই ইয়েটা চলছে আর কি, এই সার্ভিস নিয়ে প্রমোশন
3097 days delay. That means our year is 365 days. 10 years, almost 9 years. 9 years delay.
So one by one people are coming, reaching. Do you have any leader?
No.
Please give me, send him the message.
No. My lord, there is a delay of, my lord, 8 years, 176 days.
Oh, there will be very good.
My lord, allow us, my lord,
No allowance.
I will effect the service, my lord.
No, if service is not required.
Interest of justice
No service is required.
to entertain a matter
Where
after.
under the provisions of Order 41, is a notice required to be served on the,
My lord, there is an application, my lord, section 5.
maybe section 5. Let us hear it out. Let us hear what is the ground given for your deep slumber. Modern day Rip Van Winkle.
My lord, I pay, my lord, 1 day application.
No accommodation.
Only 1 day.
This matter was called on yesterday.
No, my lord. It was fixed on
Monday.
Monday.
It was called on Monday.
Monday, my lord.
No one appeared.
Monday, my lord, the section 5 application, the CAN application was filed.
Very well, we recollect. That's the reason we adjourned it. Sorry. Do the matter
Only
here.
1 day accommodation.
No,
My lord,
nothing.
I will, my lord, come back.
It's a
tomorrow.
complete abuse of process if we grant you an further adjournment of time. Complete abuse of process.
But only 1 day.
Or let us first hear you, then we will hear. What is the matter
My
about?
lord, section 5, my lord, first the appeal.
No, section 5. No, what is the parent matter?
My lord, the appeal has been filed, my lord, challenging the order dated, my lord, 30 of June 2014. That is, my lord, pertains to, my lord, Estate Acquisition Act.
Estate
Section
Act.
44 2A is involved. But kindly have a look, my lord, on the imprint board.
এই ল্যান্ড রিফর্মস অ্যাক্ট আছে দেখো তো।
My lord, I have the
44A.
44A.
Oh,
না না ওটা
estate officer.
Yes, ma'am.
শিডিউল অ্যাক্ট বোধহয়
হ্যাঁ।
শিডিউল অ্যাক্ট তো
But there is a
TT
there is a appeal under section 9. Oh, yes, we have challenged that order. Oh, the further appeal is
শিডিউল অ্যাক্টের মধ্যে পড়ে এটা ইলেকট্রিসিটিতে যাবে বলে দেখুন তো, আমার যতদূর মনে পড়ছে। আমি এসব মামলার থেকে দূরে সরে গেছি তো। Land Reforms and Tenancy Tribunal Act.
no estate acquisition act চাই।
না ল্যান্ড রিফর্মস এন্ড টেনেন্সি ট্রাইব্যুনাল অ্যাক্টের শিডিউল অ্যাক্ট বোধহয়।
হ্যাঁ, ও আচ্ছা,
শিডিউল অ্যাক্ট হলে
ল্যান্ড আপনি দিন তো
এখানে হাইকোর্টে লাই করবে না। ইলেকট্রিসিটি অ্যাক্ট আছে দেখো তো।
আমার কাছে আছে, বার করে দিচ্ছি।
হ্যাঁ, এটাতে আছে, এটাতে আছে, দেখছি কোথায়?
West Bengal State Acquisition Act is a specified act within the meaning of 2R of the
বলছি তো এটা not alternative forum, that is the forum. Whatever we are not, see, we have lost our advisory capacity. But you should have checked. See, the question is not the that of advocacy. See, whatever matters come to you, you have to accept. It is your profession. But when you are discharging your professional duties, you should be careful. You ought to have considered the Electricity Act. No, that gives you a further cause of action. You will now go and plead section prosecuting before a wrong court or prosecuting bona fide before a court without jurisdiction.
Section 40.
from the date you have filed. But before that,
ওটা দেখে নাও তো, ওই এক্সেপশনে কিছু আছে কিনা একবার জাস্ট দেখে নিতে হবে।
কোনটা?
ওই ইলেকট্রিসিটিতে এক্সেপশনে পড়বে কিনা দেখে নিতে হবে। যতদূর মনে হচ্ছে পড়বে না, তবে দেখে নিতে হবে। কেন অর্ডারটা তো 14 সালের অর্ডার।
2 months, I am trying to find out the limitation of tribunal.
Limitation of tribunal 45 days.
1 month inaction,
45 days সম্ভব।
Actually, after the review order was passed by the district judge under the year, and review application was filed. But that review application lasted till the end of 2024. On 9th of December 2024, that review application was disposed. Immediately after the review order was passed in 2014, a review application was filed. That review application lasted for last 8 years.
See,
and it took
appealable order, appeal not preferred, review preferred. Now, review application lasted for up to 24. Then how do you fall back and challenge the original order? If at all there is any challenge that can be done, is the order under review.
And
That is also impermissible in most of the cases.
but that have been a ground for my delay application. And because the review application was
when review application was disposed of?
on 9th of December 2020.
24.
20, the last year.
So go before the tribunal and satisfy.
Review application was disposed of, dismissed, observing that the review application is not mature.
Very well. Then
But it could have been a ground, but challenging that.
Oh, look at the
60 days before the tribunal.
Yes.
Section 10,
Yes.
10(2).
ও ওখানে তখন এলআরটিতে যেতে হয় বলে রিভিউটা ফাইল করেছিল।
হ্যাঁ,
অল্প বুঝতে পারছো না, বাবা রে বাবা।
review has been dismissed. So now your remedy is to challenge the original order.
Yes.
উইথড্র করতে বলবি, উইথড্র করে নিয়ে চলে যাবে টাইম। কিন্তু নো লিভ।
হুম। সেভেনে দেখো,
ও ওটা চ্যালেঞ্জ করছে না।
ওটা তো চ্যালেঞ্জ করবেন
না, ওর তো অরিজিনালটা করতে হবে।
অরিজিনালটা করতে হবে,
অরিজিনাল অরিজিনাল অর্ডার চ্যালেঞ্জ।
সেখানে একটা জাজমেন্ট আছে। যাকে আমরা কি করবো, ও যা পারে করবো, সেখানে একটা জাজমেন্ট আছে।
Will you withdraw and approach the tribunal, but we shall not grant you any leave. Because granting of leave is akin to condonation of delay.
The the appeal আমাদের আগের ডিভিশন গুলো দেখে নেওয়া উচিত ছিল। The appeal is directed against an order dated 30th June 2014, passed in Estate Acquisition Appeal number 2 of 2009. Passed by the learned District Judge Kuchbihar in ওটাকে এস্টেট অ্যাকুইজিশন অ্যাপিল না করে E.A করে দাও, অ্যাপিল নাম্বার 2 of 2009 পোস্টার। It is the case of the petitioner that immediately after passing of the said order dated 30th June 2014, a review application was filed. The said review application was rejected. Where is that order? I will.
Review application order is annexed to the application, care application.
Was কি বললাম, the review application, the said review
application was conducted
by an order dated 9th December 2024. The petitioner, the appellant therefore has challenged the original order dated ওই কত ছিল 30th কত জানো 2014 full stop. There is 30th June 2014. There is as such a delay of about
97 days as indicated in the stamp reporter report.
ও বলেছে নিশ্চয়, ও বলেছে কোথাও তো
না ও না আমি স্ট্যাম্প রিপোর্টারের রিপোর্ট অনুযায়ী বলবো।
For 8 years.
No,
হ্যাঁ কি বললাম,
This has such a delay of
about 8 years 176 days as per the appellant. It appears that the delay as per the report of the stamp reporter is
3097 days.
3097 days post-op. The appellant has made an application under section 5 of the Limitation Act 1963 for condoning the delay and for admitting the appeal. Stop. Before we go into the application for condonation of delay, we find that the Estate Acquisition Act 1954, 53 is
West Bengal State Acquisition
the West Bengal Estate Acquisition Act 1953
is a specified act
is a specified act under the
within the meaning of Section 2R of the
West
West Bengal
Bengal
Land Reforms and Tenancy Tribunal Act 1997.
97. Yes. Full stop. The appeal, if any, therefore, should be filed before the West Bengal Land Reforms and Tenancy Tribunal, in short, LRTT, constituted under the 1997 Act. Posed with this question, now posed with this fact, it is submitted on behalf of the appellant that liberty should be given to the appellant to withdraw the appeal and file before the
Tribunal.
file before the
Learned and approach the learned
and approach the learned
tribunal.
Considering the enormous delay and that an order rejecting a review application is not appealable in view of the provisions of Order 47, Rule 7 of the Code of Civil Procedure 1908. We permit the appeal. Now, we permit the appellant to approach the tribunal if permissible in law. We also clarify that the leave to the leave granted to the appellant to approach the tribunal should not be construed in any manner
And he would be, the petitioner shall be at liberty to raise the issue of pendency of the review application and pendency of this appeal to justify the delay.
Construed, we want to construed.
Should not be construed to any
Of this court having gone into the aspect of delay and condoning the same. The appeal and the connected application Yes.
Dismissed at withdrawn
No, for non-prosecution.
and dismissed for non-prosecution.
No,
Your
indulgence.
lordship was pleased to observe, my lord, that as per the appellant, my lord, 8 years, 176 days.
176 days.
176 days, my lord. However, my lord, the stamp reporter has reported 3097 days. My lord, we have converted, my lord, 3097 days to 8 years, my lord. So, my lord,
Maybe it is a
that may create, my lord, an adverse presumption.
No adverse. What is the adverse? You have said according to
But kindly add that corresponding to
no corresponding. You have according to you and according to the stamp reporter we have said. Sorry.
Item number 11.
Our service on.
At least 1 day, I forgot my preparation.
Yes?
1 day.
When was it last called on?
Yesterday.
Then?
Yesterday, first year, last one for. Second day, 1 day, for my.
every day 1 day.
Only one. Otherwise,
See, you have heard of the word Nilkontho.
only one.
We have granted so many adjournments
No,
that
not pending.
we are
matter.
saturated.
No matter.
No
It is
further
not last-
adjournment.
Not pending matter, my lord. No matter, my lord.
এই কালকে এখানে একটা বোর্ড ঝুলিয়ে দেবো তো অ্যাডজর্নমেন্ট চাইলে আর লজ্জা দিবেন
No, yes, tomorrow I will not, I say, yeah, tomorrow, my lord. Definitely, my lord. Only one, my lord, for last preparation.
What is the matter? First you tell us about the matter.
Dispute between adopted son and mother. Adopted
Yes.
son, mother claiming I revoke the license, son will be evicted from my house.
Yes.
This is the main suit. And trial court dismiss the suit of the mother, but appellate court allow the appeal of the mother.
And what about the execution?
Execution suit, I not a specific information. Recently,
No, recently.
Recently, tomorrow, I will.
We may be unmindful, but the advocate appearing on the other side may not be that unmindful. He by this time has advised him to file, advised her to file the execution. What about the execution?
But I don't have the specific information. I have to take it.
This is where difficulty is at.
ওইটা কি ওই সেই মহিলা একজন মুভ করছিলেন ওইটা কি
না
হ্যাঁ ও
হ্যাঁ
না সেটা না
ওটা না ওটা তো ওটাই ছিল হচ্ছে ওই হাজবেন্ড হচ্ছে সুট ফর ডিক্লারেশন অ্যান্ড ইনজাংশন ফাইল করেছিল হাজবেন্ড মারা গেছিল তো স্পাউস ছিল তার মধ্যে ওই স্পাউসের ইয়ে থাকে না লাইফ
ও 2G
2G তে লাইফ থাকে সেটাও পিডি করেন ভেরি ওয়েল লেট আস সি but don't embarrass us too much.
No, man. This is a difficulty. Mother will evicting this song. This is a problem. Nothing. Tomorrow, man.
Tomorrow হবে কালকেও একই হবে হ্যাঁ হ্যাঁ করে দাও আর কি করবে আরে জোর করে তো ওকে দিয়ে মামলা করাতে পারবো না ক্ষতিটা তো হবে হচ্ছে লিটিগেন্টে ও তো ফি নিয়েও নিয়েছে হেরে গেলেও ফি পাবে
Item number 12 under civil appeal.
Adjournment.
আমাকে নটু কালকে করবি একদম
If you can tell us what is the matter about, we will grant you adjournment.
I have the knowledge that this there is a first application,
Yes.
first appeal against the eviction order.
Eviction order. So you are the defendants in the suit who has suffered a decree for eviction. So when was the decree passed?
18th April 2023, Your Lordship.
18th April 2023.
Yes, Your Lordship.
Execution case filed.
As per my instruction, it has not been filed, Your Lordship. Your Lordship, kindly consider the conduct of the councils, Your Lordship, but today I would not be objecting, Your Lordship, because I have been informed that the conducting counsel for the appellant, his mother is unwell, so on that ground they have informed me. So today I would not object to their prayer. Otherwise, their conduct has been quite bad, Your Lordship. That would, if Your Lordship would peruse the last order of 21st of May, passed by this honorable court, Your Lordship, that would be clarified, Your Lordship. But today I would not be objecting,
Fair enough.
because I have already been informed, Your Lordship.
Not today or
Not today, Lordship. Not kindly make it.
huh?
Not today, not today, Lordship.
Item number 13, under application serial.
Huh? Yes.
I'm for the appeal.
You are for?
Appeal.
Who is for the respondent?
Sure, sir.
Very well.
Matrimonial suit, Lordship, petition. Appeal before your Lordship is the wife defendant.
Yes.
It was dissolved.
In favor of the husband on the ground of desertion. On the contrary, Lordship, the husband has deserted the wife. She got
Appeal
married
hearing
with
করতে
another
হবে।
man.
ওই যে অর্ডারটা হয় না ওই
Lordship, I am had an application for stay, Lordship, the defendant, he is a army personnel. So if the service book, the name of the wife of the
Should
is
not
struck
be
down, then,
removed.
The appellant will be prejudiced, Lordship. I have filed an application for stay.
stay of what?
Injunction so that he cannot remove your name
Yes.
from his service record.
কি করে হয় সেটা?
Otherwise, the wife will be prejudiced, Lordship.
Why?
Why? Her name is in the service book, Lordship.
Her name
He
is
has
in-
all, the defendant has already living with another lady, Lordship. And if the,
Maybe today, good, bad, indifferent.
if my name is struck down and her name is inserted instead of me, then I will be
No,
prejudiced.
how does this prayer lie? Today you have suffered a decree. Now you have challenged that decree. Unless the decree is stayed, how can you ask for because the marriage is no more in the eye of law. Only if you succeed in the decree, on reversal, again the marriage will be reinstated. Now, in matrimonial suit, there is only the exception that you can even ask for an injunction restraining somebody from marrying.
Yes, that can be there also there.
But how today? How today? How? Because see,
Your Lordship can
this
ask
will
about.
no. Because you are not that much clear on in the service jurisprudence you are asking for. Today, this will create a multiplicity of judicial proceedings. Today, it will create because see, service book declaration is given by the employee from time to time. It is updated. Suppose today you are into the service as an bachelor or unmarried person. When you get married, you give a declaration that I have married, so and so is my wife. When you have a child, you give a declaration. When the second child or third child are born, in similar situation. There is also a departure in case of Mohammedan. Suppose there are more than one wife. Then in that case, the names of all the wife can be included in the service book. Because though there is a dispute, because the personal law provides for, but subsequent pronouncements of the Supreme Court has put some spanner. It is a gray area, but there are judgments specific that each wife will get proportionate pension or retirement benefits, which is not permissible in case of the Hindu. Now, today, unless the decree is wiped away, how do we pass this order?
Future, there will be a problem for the.
What future?
Then Lordship kindly stay the impugned judgment.
Why? What?
Otherwise, they will execute the judgment.
মহিলা আসেনি, সে কি করবেন? ও তো লিগ্যাল এড পেতে কই আছে কেউ জানি না কি হচ্ছে ভগবান জানে।
No, you're for the appellant.
I'm for the appellant wife.
Appellant wife. Husband আসেনি।
Husband আছে।
Husband is in army, Indian army.
সে জানেও না হয়।
No, I have delivered. Sir.
You read the pair portion of your stay application. দেখে সব এখনকার দিনে ছেলে মেয়েরা না KCR will be pleased to issue a rule calling upon such and such as to why order dated then, as to why order dated what would be? Order dated
21/9/2020.
Then sentence complete. As to why order dated and if no cause or insufficient cause is shown.
এটাই চাই।
বুঝতে পারছি। As to why the order dated shall not be stayed, and if no cause or insufficient cause is shown to make the rule absolute. সে মন্ত্র পড়ার মত।
হচ্ছে কাট কপি পেয়ে।
Have you served?
ও তো লোকটাকে পারি serve the advocate was appearing. Affidavit of service filed in court today is taken on record. Despite service, the opposite party oblique husband remains unrepresented. The appeal is by the wife challenging the decree of dissolution of marriage, challenging the decree or challenging the judgment and decree dated 21st September 2024, passed by the learned additional district judge, first court at Darjeeling. কি সেন্টেন্সটা কি দাঁড়ালো?
Appeal is by the wife challenging the judgment and decree dated at
Hindu Marriage Act
passed by the learned additional district judge first court at Darjeeling.
In mat suit number 19 of 2021.
Hindu Marriage Act have you got?
In the appeal, the petitioner has also made in the appeal, the appellant of the petitioner has also made an application inter alia
You bought the plaint.
inter alia for stay of the impugned judgment and decree. Huh?
In the plaint, whether it was claimed that they started separately since 22 February 2010. Is it true? You have only given us the judgment. Plaint has not given us.
Stay application file করেছে তাতে কিছুই না।
So limitation of
হ্যাঁ?
2010 থেকে যদি বলে রিসার্টেড হচ্ছে 2 বছর পর
হ্যাঁ।
preceding the date of presentation of the suit. সুটটা করেছে 2021-এ। আর আমি একটা জায়গা পড়ে দেখলাম দেখুন started staying separately since
নোটিশ দিতে বলছি আবার। The since the appellant is seeking stay of the judgment and decree, we are inclined to give the opposite party, public husband, a further opportunity to represent, particularly keeping in mind that the husband is an army personnel. The petitioner, the appellant petitioner is granted liberty to correct the typographical error in the prayer portion of the application being can.
Proceed the examination chief of the
Can 1.
Okay, got it.
Can 1 2024. ঠিক আছে? The petitioner is, the appellant petitioner is directed to serve a further notice to the opposite party, as also to the learned advocate in the district court. Let this matter appear before the next circuit bench. আর্মির লোক এখন ছুটি ফুটি ওদের বন্ধ।
We have left him for 10 years.
So that is
His claim.
His claim. My claim is he has got married with another lady, but there he had interaction. He used to come to the house.
ঠিক আছে, যা হবে হবে, দেখা যাবে পরে। You people do not even make the basic study.
No, আমি ওটা 11 ভেবেছিলাম।
You do not, because there, even without the prayer which you are asked for, would be granted, can be obtained in a different format. In a different form. under the Army Disciplinary Act, you will find there are provisions in case of this sort of conduct of the husband. You can directly bring this to the notice and knowledge of the commander.
Now, Lordship, this decree will come in the.
You should have got it done earlier.
Okay, what can be done?
Item number 14. Item number 14.
Yes. Matsuit.
No, Lordship, this is an appeal against dismissal of suit for partition and declaration. If tomorrow today, can one is to be taken for hearing.
What is can
Can
one?
one is for application for injunction. During the proceeding of the suit, I enjoyed the injunction.
Now, why has it been dismissed?
That is also my question. That is why I have prepared this appeal, Lordship. It is admitted position that there is some partitionable property. From the order, Lordship, kindly consider page number 203, the judgment of the.
See, if I correctly remember, you said yesterday there were 11 properties in the schedule.
11, no, one, what is 11 acre?
11 acre. Oh, sorry, 11 acre. 5 acres out of that has been found to be
Gifted.
Cannot be partitioned. But the balance 6 acres can be partitioned.
That was admitted by the defendant.
So in that situation, your case is that how do
dismiss the suit entirely. That is one of the point, and the gift deeds by which they are claiming to be absolute right over these 5 acres of land. I have also challenged the execution of that gift deed. On that ground, that these gift deeds were not properly attested by the as per section 123 of the Transfer of Property Act. It has to be attested by two witnesses.
One witness has attested.
Two deeds have been attested by one witnesses.
There are 3 deeds probably.
5 deeds, 6 deeds. 6 deeds. And in other deeds, by which the different number 2 and 6, 2 and 4. No, sorry, 2 and 3. 2 and 3 said they have not accepted the gift during the lifetime. Their admission is there. They did not accept the gift. So my question is, when they have admitted in the pleading and as well as during the examination that they did not accept during the lifetime of the donor, and there is and another 2 deeds, there is only one witnesses. So these 2 deeds were also should not be considered as a valid gift. So this will also come in the aspect of the partition. The other properties in respect of which
we are now at the stage of injunction.
So I have a prima facie case. Because admittedly there is partitionable property. The entire suit should not have been disposed of, and the challenge against the gift deeds are also
two things. One aspect is the entire suit should not have been dismissed. That is subject matter of appeal. Today, if we go by the findings, I have not opened the papers. By the findings, subject to further scrutiny, if out of 11 acres, say 5 acres,
5.9 acres,
5.9 acres is partitionable. The rest, it has been held that belongs to the defendants. Now you are asking injunction in respect of which?
Entire property.
Entire property.
Because I have also challenged the gift deed.
Just a minute. If it is for the entire property, then at least the balance one, say 6.1 or something like that, 5.1.
5.15.
5.15.
Total 11.05%.
As of now, is an exclusive property of the defendants.
Subject to the fate of this appeal.
As of now, I have used the word. So, in respect of that 5.15 acres, how do you satisfy the court for granting an injunction?
If injunction is not granted, and I have challenged the execution of the gift deeds, and this is also subject matter of the appeal. And if the injunction is not granted, they transfer the property, multiple interest will be created. And in that case, I will suffer irreparable losses.
But what will happen to the dictum that if it is my property, I am entitled to freely enjoy the property. Today, your challenge to the deeds did not succeed. And that is the reason the injunction, that is the reason the suit was dismissed, and as a consequence of the appeal filed. Now, at this stage, in respect of that 5 acres, how can?
So my suit did not succeed because there was an error on the part of the learned court below. Because
we take it on the face value.
Lordship.
So far as the 5.9 acres is concerned, it is in a different pedestal. And so far as 5.15, it is in a different pedestal.
I have challenged the right capital and interest in respect of the property because I have claimed it to be a joint property. If it is after the end of this appeal, if it is found that it is actually a joint property, it should be treated as a joint property. And in the meantime, they create a third party interest in respect of the property or changes the nature and character of the property. Then and make the suit property irreversible.
What is the relationship between
brothers?
Huh?
Brothers and sisters.
Own brothers?
No, not brothers. Brothers, son and daughter. And
No, own brothers.
Own brothers. Common predecessor. Bankim Chandra Rai was the father of the appellant and grandfather of the defendant number 1, 2. 1A to E and 2A to D. And 3 and 4 was the daughter of Bankim Chandra Rai. And this is an admit question.
Yes, Mr. Ghosh.
Why the court, the landed court below, did not even consider the remaining property? The reasons are recorded in the order. It's very clear. They have described in the plaint only one schedule comprised of 11.05 acres. The remaining 5 acres, upon which they claim that it still remains to be a joint property, that has not been described in the plaint. There was no question of it because they were proceeded on the basis that 11.05 acres is the unpartitionable property. So the court did not have any occasion to have that 5 acres in a separate schedule or with a specific boundary.
Mr. Ghosh, if you ask me, I will give you 2 judgments. Even
molding of.
No, not molding. Even after passing of the decree, the schedule can be amended.
Can be done, could have been done at the instance of the plaintiff.
No, the court.
Passing the preliminary decree could have been amended.
Now, today Milord is considering an appeal where the 5 acres, there is no boundary, no description, nothing, on which the court will grant injunction.
Could be identified during the final decree.
No application taken out. Court also did not do it so.
No, the 11 acre includes the 5 acres.
According to them, yes.
Oh, and they describe the particulars of this 5 acre in the plaint.
No, they did not. 11 acres with a schedule.
Entire 11 acres
পুরো জমিটা 11 একর, ঠিক আছে? এর মধ্যে ওর বক্তব্য হচ্ছে বঙ্কিমচন্দ্র রায়ের জমি, সেটা হচ্ছে তার ইয়াসদের মধ্যে এসছে, ঠিক আছে? এবারে ইয়াসদের মধ্যে এসছে, তো ইট ইজ অ্যান আনডিভাইডেড প্রপার্টি, পার্টিশন চেয়েছে। এবার এর মধ্যে বঙ্কিমচন্দ্র রায়কে দিয়ে হয়তো ওই গিফট ডিড করিয়ে নিয়েছিল ওই এই ডিফেন্ডেন্ট নাম্বার ওয়ান সেট আর টু সেটের ওই বাবা দিয়ে করিয়ে নিয়ে বলছে এটা আমাদের এক্সক্লুসিভ প্রপার্টি ঠিক আছে।
They have said it in the written statement. That I have amended the plan.
এই গল্পটা হয়েছে। এবারে প্রশ্নটা হচ্ছে যে ওটা গিফট হয়েছে কি হয়নি, দ্যাট ওয়াজ অলসো সামহার চ্যালেঞ্জ। এইবারেতে কোর্ট রিজেক্ট করে দিয়েছে পুরোটা। প্রথম কথা হচ্ছে কোর্ট এইরকম সিচুয়েশনে কোর্ট কোথাও একটা লোকাল কমিশন করলো না, কিচ্ছু করলো না, তার বেসিসে রিজেক্ট করলো, ঠিক আছে।
The moment below the gift deeds came into picture by way of a written statement.
See, the gift deeds came into picture. What is the situation of the record of rights?
Record of rights gift deeds acted upon. Record of rights created on the basis on the name of the donors. Now the moment the gift deeds came into picture,
when the record of rights were given, did they have the notice?
No. That too, I'm not whether other
one record of right was prepared after the death of the donor.
But
at
the same time,
notice was served. That is my question.
Even
Because
they did not take any steps.
If you look into the Land Reforms Act or any other act,
Co-sharers have to be served with the notice. But they have also not taken any steps for rectification of the record of rights. Number one. Number two, acts of gift deeds came into the written statement. It was a duty incumbent upon the plaintiff to segregate the schedules. Because that 5 acres, which is not subject matter of the gift
That means that your absolute ownership will be accepted by them. Why they will do it?
But
Mr. Go.
But Milord, the nature of those plans were absolutely
we are inclined to grant the
Maintain status quo. Maintain status quo.
No boundary, nothing.
Shoot property.
the entire property
Entire shoot property.
Bankim-Chandra.
Subject to correction, Milord, there is no prima facie case made out. Can you see that?
Okay, we are
It's a
saying
51 page.
we are saying
51 page judgment.
Entire plain and written statement was
এইটা করো এদিকে এসো।
There's a 51 page judgment, Milord.
See,
Absolutely well reasoned.
See, 51 page judgment may be a scrap of papers. 5 page judgment may be more than 51 pages.
But Milord, my only submission is, Milord, it is absolutely well reasoned why their prayer was rejected. The entirety of
See, end of the day, Mr. Ghosh, you will agree, not as an advocate holding the brief, but as an officer of the court. If this protection is not granted, there will be a series of multiplicity of judicial
Milord, I absolutely bow down to that. But Milord, absolutely, Milord, on the face of it, there should be some infirmity pointed out to the court, which would prompt this honorable court to pass an order of status quo. Just merely because he has preferred an appeal.
No.
The difficulty you will face, or the difficulty in resisting the injunction, this is a partition suit.
I understand.
In a partition suit,
it is a first appeal.
In a partition suit, the position of the plaintiff and the defendants are the same. So, in such a situation, when the predecessor is common, there has to be some protection. Otherwise, এমন একটা ছেলেকে খুব ভালো লেগেছিল তাকে
It was not even gifted to the son. The son's son.
See, it is not unnatural.
Mr. Ghosh gave this plan.
Not
Mr. Ghosh gave this plan.
Under the circumstances, how it was gifted.
আচ্ছা, এই করো। কেন? In an appeal preferred against the judgment and order dated. Judgment and decree dated 9 July 2024, passed by the learned civil judge, senior division at Alipurduar, in partition suit number 19 of 2020. কি দিয়ে শুরু করেছি?
Leader appeal preferred against the judgment.
By the
Plaintiff appellant.
by the plaintiff, challenging the dismissal of the partition suit number 19 of 2020. The appellant has filed this application for injunction. It is the case of the applicant that Bankim Chandra Rai, the father of the appellant and the grandfather of the defendants respondents number 1, 2,
predecessor interest.
now 1 to 7.
পরে আবার substitute হয়েছে।
Actually, son's wife, daughter-in-law is also there.
The lineage is slightly lengthy. 1A to 1E.
No, but here he has made respondents 1, 2, 3. You tell us which respondents. No, বললি মুশকিল।
Number 28 is the plaintiff.
No, from the appeal who?
ডিগ্রিটাই যেতে হবে,
ডিগ্রিটা না প্লেন্টে হবে, তা এখানে ও তো সিরিয়ালি নম্বর করে দিয়েছে।
ডিগ্রিটা হচ্ছে পরিমল রায়, দীপক রায় বঙ্কিম রায়ের ছেলে। আচ্ছা, আর পরিমল রায়, রমানাথ রায়, মিঠুন রায়, এটা কমল রায়ের, কমল কৃষ্ণর ছেলে হলো। জয়া হচ্ছে কমল কৃষ্ণর মেয়ে, কমল কৃষ্ণর ওয়াইফ। কমল কৃষ্ণটা হচ্ছে হু ইজ কমল কৃষ্ণ?
He was a son of the Bankim Chandra.
Son of Bankim Chandra.
আচ্ছা, grandfather of defendant number 1 to 4. Joya Rai is the daughter of Kamal Krishna. Who was Kamal Krishna? Where is the genealogical table?
It's not there, but I have, in my note, I have prepared a genealogy, but you can see the judgment, the opening first paragraph, first page. Page 2 of the judgment that has Millard somehow summarized it.
আচ্ছা, এইভাবে করো, কি বল?
Case of the applicant that Bankim Chandra Rai,
Bankim Chandra Rai had how many sons?
But 5. Fultuli, Jugal, Amullo, Ranjit, and Kamal Krishna. Ranjit predeceased the father. Ranjit were left behind four children. Slightly lengthy, Miller, the table would have helped.
One is Kamal Krishna.
Yes.
One is Ranjit.
One is Ranjit, one is Amullo, one is Jugal, and one is Fultoli. Fultoli was his wife.
আচ্ছা, ঠিক আছে, তাহলে কি হলো?
is the case of the applicant that Bankim Chandra Rai had
5 sons, namely দীপক চন্দ্র রায়, ব্র্যাকেটে হচ্ছে প্লেন্টিফ অবলিক অ্যাপেলেন্ট, কমল কৃষ্ণ রয়, Ranjit Kumar Rai,
Amulya Chandra Rai and Jugal Chandra Rai.
where do I get that?
অমূল্য চন্দ্র রায় ইয়ে
In the judgment.
Jugal died without any issue.
ও
কিন্তু
হ্যাঁ,
শান্ত
কি-
বটে।
কি- তাহলে
And five sons, namely.
was survived. ওকে এটা এইভাবে করে দাও।
It is the case of the applicant that Bankim Chandra Rai was
Survived by
two
by
sons,
five sons.
না
by three sons
three sons and
and two daughters.
two daughters.
Three sons, namely, এখানে তো
না ওই হ্যাঁ three sons namely such and such and two
কে কে দীপক
হ্যাঁ দীপক, Kamal Krishna, Ranjit, and two daughters namely Minoti Rai and Bina Rai. ঠিক আছে? On the death of Bankim Chandra Rai, the schedule, the property mentioned, property described in the schedule of the plaint
devolved upon
ঠিক আছে, devolved upon his surviving son and daughters. Wife was present at that time.
No.
Full stop. The scheduled property, therefore, according to the plaintiff, is a joint property. The joint and undivided property. The plaintiff of the appellate, therefore, sought for partition of the scheduled property. In the written statement, the defendants came up.
Defendant number 1A to E and 4 came up with this.
কি বললাম?
in the written statement, the defendant
In the written statement, the legal heirs of Kamal Krishna Rai and Ranjit Kumar Rai.
The legal heirs of Ranjit Kumar Rai did not accept the gift. They have filed separate written statement.
Acha. Then Kamal Krishna. Yes, of
heirs of Kamal Krishna Rai
being the defendants number 1, small a.
Small a to E.
Small a to E.
And 4.
And defendant number and 4 contended that a portion of the scheduled property has been gifted to them by gifted to them by Bankim Kumar Rai, Bankim Chandra Rai during his lifetime, by virtue of which the said defendants have become exclusive owner of a portion of the scheduled property measuring about 5.15 acres.
5.15 acres.
0.15 acres. Full stop. The plaintiff therefore amended the plaint and challenged the deed of gifts put forth by the defendants number 1A to E. Full stop. it is the case of the plaintiff that the learned trial court after accepting that a portion of the scheduled property measuring about 5.9 5.9 acres
9 acres remaining
was joint joint property and undivided, rejected the claim of the plaintiff in entirety. Next, in this application, the plaintiff, the appellant of the plaintiff says that before the trial court, the plaintiff had plaintiff was favored with an order of injunction in respect of the scheduled property. The same first of the and as such, the same injunction should be extended during the pendency of the appeal to avoid multiplicity of judicial proceedings. It is also the case of the plaintiff that in the event plaintiff succeeds in the appeal and during the interregnum, the defendants dispose of the portion measuring about 5.15 acres, then the plaintiff will suffer irreparable loss and prejudice apart from multiplicity of judicial proceedings. Furthermore, if the said portion is disposed of, the suit of the reliefs claimed by the relief of partition claimed by the plaintiff in the suit will become infructuous even if the plaintiff succeeds in the appeal. Resisting the prayer of the plaintiff is submitted by the defendant's number, by the respondent's number.
all the response
Submitted by the respondents that the gift deeds have been acted upon, and on that basis, the name of the respondents, the name of some of the respondents have been mutated in the record of rights pertaining to the said 5.15 acres of land. Moreover, the entire plot of land is undemarcated, and as such, the order of injunction as prayed for by the plaintiff will not only infringe their right to use an enjoyment, to the exclusive right to use an enjoyment of the said 5.15 acres of land, but will also create complication. It is also submitted by the defendants that the trial court, by a well-reasoned judgment, has detailed the reasons for
declining to act reason for refusing to petition contest. Plaintiff contest.
The trial court, by a well-reasoned judgment, has detailed the reasons for
which the suit was dismissed. It is the further case of the defendants that the plaintiff did not make any segregation in the schedule of the property, and regarding the 5.15 acres and 5.9 acres, and as such, it was not possible for the trial court to grant any decree in respect of the 5.9 acres of land. Be that as it may, we find that the predecessor in interest from whom the appellant and the respondents claim to have either inherited or by exclusive right under the gift deed has got the property or portion of the property in question is common. The property is still undemarcated according to the own admission of the defendants. Though some of the defendants claim exclusive right in respect of 5.15 acres of. In the aforesaid facts and circumstances, we find that the balance of convenience and inconvenience is tilted towards the appellant